This hearing is in the matter of case number CFI 052-2021 before Justice Wayne Martin. The hearing is being held by way of video conference in the DIFC courts in Dubai. Any orders or directions made during or after the course of this hearing will be issued by the registry on the judge's instructions. The claimant is represented by Khalifa bin Huwaidan al-Kitbi advocates and legal consultants. Lead counsel is Mr. P.V. Danish. The defendants are represented by DWF Middle East LLP. Lead counsel is Ms. Emma Walker. Thank you.
Thank you. Mr. Dinesh, would you like to open the case for your client?
I'm sorry. One second, please. I'm sorry. Yes, I'm sorry.
Would you like to open the case? Do you have any oral opening submissions to make on behalf of your client?
Yes. I would like to make a brief oral submission, just an overview of the case. I will not go into the details of the issue, which I will leave for my final summary submissions. And first of all, my apology because the issue is very short, but we have made it so bulky and more than 2,800 pages and troubling, Your Honor. I believe that both of us could have reduced the number of pages. Unfortunately, that did not happen. I'll just make the brief submissions so far as the issue is concerned. Issue is very short. We, the claimant, I'm not referring to any document for the time being. We, the claimant, is a fish exporter, fish and meat exporter. We are also a processor, and we source goods from different countries for the purpose of export as well as the local sale. So, and the defendant, there are two defendants here. The first defendant is a local company based out of Dubai, UAE. And the second defendant is their international parent company. And in the course, and both of the claimant as well as the defendant, we are engaged in exporting goods as well as local sales. In the course of business, we have been giving products for UN supply and all other normal export activities and processing activities. And East Fish and the ECOLOG, that is defendant, I'm just using the word ECOLOG, I think I pronounced it correctly. ECOLOG is a huge company which is supplying everything, medicines, pharmaceuticals, furniture, fish, food, everything to UN missions in Africa, particularly in Mali, as well as Central African Republic, CAR. So far as these two contract is concerned, we have two countries, that is Mali, and the other one is Central African Republic. So this business was continuing from 2014 onwards, and we have been supplying to East Fish, and still we are supplying to many other agencies which are supplying products to UN. So in this case, there is no master service agreement. And there is only purchase orders here. And purchase order is only a simple one-page document, which I'll take Your Honor to that document later. Purchase order is only just one page. I can straight away take right now, if then that will be a base for the further arguments. Any purchase order for that reason. I'm just opening my system. Give me a copy of the purchase order.
Mr. Dinesh, how many purchase orders are there?
There are multiple purchase orders. So far as these purchase orders are concerned, before taking Your Honor to the purchase order, I can give a summary again and come back to the purchase order. That will make the situation a bit more clear. Or Your Honor would like to see the purchase order right now?
Well, it would help me at some point if I could have a list of all the purchase orders that are relevant to these proceedings. That would be helpful.
Yes, the 0140. Kindly come to 0114.
Yes, I have that.
Yes, this is a simple sample purchase order. Kindly see, then the issue will be more easier. There are two pages. There is the first page and the back page of it. There are only two pages.
Yes.
And kindly see the purchase order. The vendor is East Yes. Your Honor is at page 114.
Yes.
Yes. Kindly see the vendor, Eastfish Processing LLC. That is the claimant. And the customer is ECOLOG International FZE, Dubai Airport Free Zone. This is the customer. And the purchase order number is the date is there, that is 10/2/2019, currency and the Incoterms and payment terms is basically 60 days from the payment terms of after the invoice or after the delivery, which can be interpreted in whichever manner. Buyer's name is Steven D'Souza, the procurement department of the defendant, and buyer's telephone number, buyer's email ID, all absent, and mode of payment is ACH payments, and storage location is in Dubai. And this purchase order, there are two clauses. In the middle, this purchase order, along with the ECOLOG International Terms and Conditions of Purchase, along with all manuals and policies. Unfortunately, that is not. It is not the case, and it has not been produced anywhere, which are stated or incorporated by reference therein, constitute the entire agreement between the parties and supersedes all previous written or oral agreements relating to the subject matter, unless the vendor has executed a master service agreement with the customer, in which case the terms of that master service shall supersede the terms contained herein. So this is the opening clause, which says that the purchase order supersedes all correspondence and communications unless there is a master service agreement between the parties. And if there is a master service agreement, that will have precedence over the purchase order. Otherwise, it is purely based on a purchase order based contract. And kindly come to the next page, that is 0115. Only 10, 11 clauses so far as this contract is concerned. The purchase order, I think it will be, because both parties may be relying on this purchase order. So at one go, we can finish this. The purchase order constitutes a legally binding agreement between the vendor and the customer. Second, the price of goods defined above shall be as set out in the purchase order or in default of such provision, shall be calculated in accordance with the vendor's scale of charges as advised by the vendor, received acknowledged. There is no dispute so far as clause 2 is concerned. That is only in respect of pricing. And 3, the vendor shall invoice the customer for the goods no sooner than the completion of delivery of the goods, or if later, the customer's acceptance of the goods. So whenever the goods are delivered, immediately there will be an invoice, and the clause 4, 5, 6, 7, 8, 9 are disputed, and they may be subject to interpretation by both parties. And clause 4, the Lordship is referring to. May I continue reading, or should I stop reading, my lords? I'm sorry, I miss your honor. I miss your honor. I miss your honor.
So I'm yet. Look, I can read the clauses are on the screen in front of me, so there's little to be gained in reading them to me. But I am interested in what you say about the effect of the clauses.
Oral submissions, you mean?
Yes. So
I'll just take you to the FZE.
Reading the clauses out to me is pointless because they're on the screen in front of me and I can read. But tell me what you say is significant about them.
Yeah, significance is basically, I'll just orally make submissions on this clauses. Basically, the clause talks about that basically all these clauses say that the delivery should be there, and the delivery 6 says the time of delivery is the essence, and delivery says it should be if the vendor fails to deliver any of the goods by the date specified in the order, the customer shall, without prejudice to its other rights and remedies, be entitled at the customer's sole discretion to terminate the contract in whose or in part to purchase the same similar goods from the supplier other than the vendor and recover from the vendor all costs and losses resulting to the customer. And as per this purchase order,
so what are you reading from now?
Yes,
that's clause 6.
Yes, clause 6 I read. And
yes.
As per, I'll just make oral submissions, and that will be keep coming again during the course of these arguments. But orally, what I wanted to convey is that as per this purchase order, the buyer has to make the payment within 60 days of the payment. And kindly come back to the page 0114, that the first page. Here, the interesting part of this entire contract is it is not an export transaction, as generally we get an impression that it is an export transaction. we have the factory based out of UAE, and the buyer here, the buyer is referred as customer because there is no consumer here. We are only concerned about the customer. And as per this purchase order, the buyer is called as customer. And this customer is coming to our factory. We are storing the goods at our factory. We are collecting goods from all over the world and collecting and storing these items in our factory. And what they do is they come, they arrange containers, they arrange their own representatives as their own quality control inspectors. They come and visit our factory and take delivery of the goods. So what happens is the same day the delivery takes place. It is not like an international transaction where I export something and the party is receiving it after 3 months or 4 months. On this, that is the reason why. Kindly come to the first.
But Mr. Dinesh, can I draw your attention to clause 5 on page 2?
Yes.
Which contains the warranty that the goods shall strictly conform, and then it provides for the avoidance of doubt. The vendor shall remain liable for the goods until the customer has had an opportunity to inspect them at their final delivery destination.
Absolutely. Absolutely.
Well, how does that fit in with what you've just been saying?
Yes. Here, the final, so far as, before I'll just satisfy the question, kindly come to the first part of the purchase order. First part of the purchase order, where the date of invoice and date of delivery, kindly see the date purchase order dated is 10/2/2019 and delivery is 14/2/2019. I understand the question. So what happens is the delivery takes place on the invoice date itself. And we all know, I'm not running away from the fact that these goods are meant for UN mission consumption. So what happens is I have a duty, I have an obligation to see that whatever the goods I supplied is in terms with the purchase order. And I am selling these goods to the buyer, who is the customer, and customer has got a number of agreements with UN, and that is not presented or produced, or any witnesses also produced, witnesses not examined.
Well, let's just focus on the point that I'm asking of you, because you seem to be submitting that your client was not responsible for anything that happened after it left the factory.
No, I'm not saying so. My client is responsible. My client is responsible. That's why I said I can't run away. I have a duty. I have an express duty. I have an implied duty to see that the products which I supply to the customer is as per my expressions and the way I really acknowledge it to the other party or represent it to the other party.
One other question arising from page 14. The customer is said to be the first defendant. What's the basis for your claim against the second defendant?
The second defendant, the customer is first defendant, means my job will be all the more easier because the sale takes place only in Dubai. There is no UN in the picture at all. Because
let me just repeat the question, Mr. Dinesh.
Yes.
You're relying upon this contract, which is a contract between the claimant and the first defendant.
True.
What is the basis of your claim against the second defendant?
Second defendant, by their action and during the course of transaction, the second defendant is in the picture, and throughout the contract, they, as well as the first defendant officers, they were contacting us and they were responding to us as if they are the customers. It's purely they are representing as one entity.
What is the legal basis for the claim against the second defendant? You've told me what happened, but what is the legal basis for the claim? Are you saying that they became a party to the contract, or what? I don't understand how that. The contract is governed by the laws of England. Yes. So tell me which law of England makes the second defendant responsible under the contract?
So far as this contract is concerned, it is between two parties and two legal entities. And
which two parties?
The parties that is Dubai party, the first defendant, Dubai ECOLOG.
So it's the claimant and the first defendant.
The customer here is ECOLOG International. I'm sorry, customer is
International. FZE, which is the corporate entity. That's the first defendant.
That's the first defendant.
So why have you sued the second defendant?
Second defendant, of course, it is the second defendant is an agent of the first defendant.
Well,
second defendant.
That doesn't make the agent isn't liable for the acts of the principal.
True.
So why have you sued the second defendant?
Second defendant acted as representative and agent of the first defendant, and they took delivery on the behalf. First defendant has no case that they took delivery from us directly.
I still don't understand why that has anything to do with you're claiming under the contract for payment due. The payment on the face of the document is due from the first defendant. So I still don't understand why you've sued the second defendant.
That is the way the first defendant has been acting, and first defendant through email correspondence we have been contacting and saying that look, they are our agencies. Of course, agent, whatever done by the agent.
An agent isn't responsible for the agent. Under English law, an agent is a means by which a contractual relationship can be formed between two parties, including the agent's principal. The agent is only liable under the contract in very limited circumstances.
Sure.
I'm still struggling to see, even if the second defendant was the first defendant's agent, how does that impose any liability on the second defendant?
I understand the question. So far as the contract is concerned, second defendant is not a party. But
well, then I can't see any, and I've given you many opportunities. I just can't see any basis for the claim against the second defendant. But
I perfectly understand the question, and I also understand the situation that second defendant, there is not contractual relationship with second defendant. That is what your honor is telling me. I understand that, and even if he is an agent, agent's liability is restricted, or agent's liability comes in certain circumstances.
Well, if there's a breach of the warranty, if there's a breach of the warranty of authority.
Breach of warranty, or if he acts beyond the instruction. Yes, if the agent acts beyond the instruction, fine. Agent may be liable independently. But here in these circumstances, in this contract, so far as this particularity of this contract is concerned, the second defendant was acting, and second defendant was representing that they are one and the same. Might be a lifting of the corporate veil, because a case were.
Mr. Dinesh, I think we're drifting off. I can't see much turns on this, but you haven't pleaded or suggested any lifting of the corporate veil. I just can't see any basis for that contention. But it doesn't really matter, I don't think, because unless there are issues of insolvency, which I don't think there are, it doesn't really matter, does it? There might be cost consequences of the discussion we've been having, but I can't see any other consequences, practical consequences.
But Your Honor, even if second defendant, whether the liability is on the first defendant to make the payment, no doubt about it, because we delivered the goods to the first defendant. But so far as this contractual term is concerned, whether second defendant is there or not, that is not going to alter the situation at all, because the first defendant collected the goods at our factory, from our factory. So whichever manner they collected it, whether they use the second defendant, that is purely an internal arrangement between the first defendant and second defendant. And normally the second defendant is also party to the transaction here. Tomorrow there may be a question saying that, look, you have not added a necessary party here. Of course, this is not an arbitration where purely two parties who are based out of the contract are arbitrating. It's a suit for damages and claim, where if I'm not adding the second defendant, that would be an adverse inference can be drawn against me, saying that the necessary party who was fully involved in the transaction is not made a party here.
Right.
Of course, I appreciate the depth of the question, and can I move forward, Your Honor, please? Please. I will also try to give you a better answer during the course of the proceedings by referring to documents. Lords, so here we delivered the goods. They collected the goods from our factory. They arranged the containers, trucks, the quality controllers. They came, inspected the goods, and sent to their warehouses. kindly see the purchase order. There is no address. There is no address of any of the UN missions. The purchase order is blank. Kindly see the purchase order is blank. The destination is blank there, only the customer. Because that is the reason why normally in international commerce and this trade, the destination of the final or the buyer will be there where I'm supposed to export to a particular destination. Here that is missing from the purchase order for the reason that it was just buy and sell. It's a local, and interestingly, this purchase order is called as local purchase order, LPO. I can also show that citing one of the purchase orders saying that they purchased items for local market in UAE through the same purchase order. They ordered fish and other items, but they ordered meat and other items to be delivered to the local destinations in UAE. So far as we are concerned, we are conscious and aware. I'm not hiding from the fact that it was not meant for UN consumption. That would be a worry of my learned friend that if I am going to deny that aspect, I'm not going to deny that aspect. And it's ultimately meant for UN mission consumption, which I can't run away. The documents speak. And my lords, so during this transaction, they took delivery. And for the first time, we have a relationship for the last 10 years, 8 years to be specific. And they have been consuming, they have been giving to various UN missions as per their back-to-back contract. And on 5th of February, I'm just giving you the dates. I'll refer to the mail later. On 5th of February, all of a sudden, they're sending a mail to us saying that, look, your fish which you have sent has got more glazing because the officers at UN mission in Mali said the glazing percentage is more. Your Honor, may I mention what is this glazing? I'm sorry, my lords, I'm missing your lordships in
I think I understand. It's the ice, isn't it? So the fish is frozen in ice, and it's the percentage of the block, if you like, that is fish, and the percentage that's frozen water. That's it, isn't it?
Your Honor is absolutely right. That is a ice coating. Yes. Ice coating for the protection of the fish. So yes. Interestingly, what by glazing means that you have to keep the character of the fish intact. And that is more important. Just coating is not enough. You have to keep the character and preserve the fish as it is and give a coating. Some people, depending on the weather conditions, they may insist for a more percentage of coating, that is this glazing, and some people may request for less percentage of glazing. So far as this UN contract, we have been producing and we have been supplying as per the customer's demand, whether it is 20% glazing or 40% glazing. Here on the label, it was 20% glazing. I'm mentioning Defendant's case. Here in the label, it was 20% glazing. And on 5th of February 2019, they sent a mail saying that there was a test conducted by UN and the glazing percentage is more. When we received this, we said, yes, we have got a relationship for 8 years. We have no problem because ultimately it's a matter of adjustment of price because the net weight is based on the percentage of glazing because you have to deduct out of the gross weight the glazing percentage and the weight of the glazing, then you get the net weight. So ultimately the transaction and price is paid on the basis of the net weight. So we said, fine. Ultimately, what matters is the net weight. If you have an issue, we can look into this issue and you don't need to trouble. And we also have the fear of losing a big customer. So we don't want to because it's an 8-year-old relationship and we don't want to spoil the relationship. So we did not accept it, saying that, look, our product was not in accordance with the label, but we said, fine, we can be with you in this process and we are ready to support you. And we move forward. Then they said, look, we are trying to speak to UN authorities, a series of telephonic conversations happening in between, mail exchanges happening in between, and Dubai there as second defendant coming into the picture. Second defendant officers are talking to us, they're mailing to us, look, we have some issues with the UN. We said, fine, if you have an issue, then we can take it back. We can adjust the goods. We can adjust the entire situation. Then they said, no, sorry, we can't do that now because once you send to UN, you can't take it back. There is a process where once the goods are supplied to UN, you can't take it back. Interestingly, this is a sale by description. This is not a sale by sample as per the Act, Sale of Goods Act. This is sale by description. And we said, look, this is a situation. Please make arrangements to send it back. Then they came out with an explanation saying that no, once we send to the UN, we are not in a position to send it back. And then on that process, again, the mail exchanges, talking take place. And interestingly, this happens in the month of February. To kindly note this date, Your Honor, February 2019. And in between this inform us, look, apart from glazing, there are other issues because some of the items which you sent is not as per the species, because you sent claiming that it belongs to a particular species, but we doubt, and this is not from that particular species, it has to be examined. And they say, look, we have a laboratory for testing this, and we are sending it. They did not inform us in advance. They send these products to Eurofins laboratory in Hamburg. And they sent us a test report of 3 products. And interestingly, these 3 products, specimens and samples are sent from Central African Republic, CAR, not from Mali. And the CAR, they sent 3 products out of the 7, 8 products. They sent 3 products and say that we are sending these products, and they send us a DHL airway bill showing the sending of these 3 items to Germany from CAR, and give us a report saying that, look, as per the Eurofins test, this is not as per the samples. And the third issue, there are broadly 3 issues. One is glazing, second is species, and the third one is they say that, look, you delivered a fish item, but when you look at the Food and Agricultural Organization FAO chart, the origin of that particular species is not from the country of origin you represented. That is what they said. So broadly, we have been questioned on 3 aspects. First is glazing. The second is species. The third one is the country of origin of the fish. So there is 3 misrepresentation or the delivery of the products not in accordance with the representation or labeling. This is a case against us, in short. Then, interestingly, we said, look, initially they said UN can't reject, we can't send it back. We don't know what really transpired between UN and ECOLOG. We have been sending a series of mails. Please provide us a simple proof, something from UN saying that, look, this is the test result or these are the products, because it comes about 400,000 US dollars, the total comes. And they just send 3 packets for testing and say that, look, your products are rejected. 3 kilos out of the 400,000 total products, they just test 2-3 kilos and say that your entire product is discarded and is rejected by UN. And we were anxious because we have been supplying these products for the last 8 years. We said, at least give us some evidence to show that these products are not as per the labeling. That is the sole case here. There is nothing on record. And even this entire proceedings, they have not except 2 mails, which is purported to have issued by UN. And that also I'll come to the veracity of those mails. There is nothing on record, no documents produced, no witness statement filed so far as this cardinal and very important issue so far as we are concerned. Then, so for the purpose of this mitigating I'm sorry, Your Honor. Your Honor.
What is the very important issue that you say there's no evidence on? You just said that there's no witness statement, no evidence in relation to this very important issue. What is the issue that you're talking about?
The mitigating of damages, mitigating of my loss, and sending back the products. As well as testing. I'll just come to the testing aspect. There are two issues. One is the testing issue. The second one is mitigating the loss, where they have a duty to send it back as per FAO standards.
Yes, all right. Well, let's on the testing issue, which is what I thought you were talking about.
Yes.
Your complaint is that the items tested weren't sufficient to enable conclusions to be drawn with respect to the items that weren't tested. Is that the proposition?
My proposition is, they say there is a testing by UN, and they send us certain photographs to us. Look, this is by testing, and this has been tested as per the Cordis Alimentarius, that is the standard of testing, and they conducted this test. There is no value, nothing so far as this testing is concerned. It is just sending two photographs of one or two products, and we sent a very bulk quantity. They sent us a testing report that too without any value proposition, without any values. They sent one photograph and tested one particular item. Out of the whole lot of stuff, they tested a small quantity, which is not a representative character, a representative specimen of the entire consignment. There are various lots, various consignments, various batch numbers. It is not at all a representative specimen of the entire test. And for any scientific test, I go by Cordis Alimentarius. If they say that your testing method is totally obscure and very, very old, and you have to go by the international standards of testing, and I agree, for the argument's sake, let us go by the international standards of testing. I have my own reasons why we do a particular test, which is an accepted test by any other person in Arab countries, and so far as other UN supplies are concerned. I have my own reasons, and I'll explain that. But so far as this issue is concerned, first they said they conducted a glazing test and sent us a few photographs and said that, look, we conducted a test as per Cordis Alimentarius. There is nothing to show that has been done as per Cordis Alimentarius or the Cordis standard.
What is Cordis Alimentarius? What are you referring to? I don't understand that.
I'll just come to this. That is the witness statement, the expert opinion given by the defendant. I'll just orally submit what it is, and I'll come to this. In Dubai, UAE, there is a particular way of testing of glazing, and they came out and the expert says that, look, your testing method is wrong and it should be as per the international standard of testing of glazing. And for the purpose of understanding, let us proceed that this Codex Alimentarius, the Codex is an international testing method which is accepted and which we will be going. I'll explain it what is Codex Alimentarius. The Codex Alimentarius, according to them, is that the glazing can be removed, or for it can be deglazed by keeping deglazing is as per the Codex, as per the expert they have produced, the expert witness statement, it should be sprayed with water with a temperature of 27 degrees Celsius. And you can find out the ice content. So it should be gently sprayed because the fish is preserved. You cannot use a jet water. It should be gently sprayed with water with temperature of 27 degrees Celsius. Then you have to see the pre-weight of the product and the post-weight after deglazing. That is the pre-weight of the deglazing before deglazing and the post-weight after deglazing, and you find out the glazing percentage. This is the Codex. According to them, they said that is a test you should have conducted. And so far as UAE test, we said we conduct the test in a different manner because the UAE temperature is very high. Here what we do, the testing method is this: we use chill water, that is the weather temperature is 0 to 5%, and we use this chill water and spray this, use it, and find out the glaze method. According to the expert opinion, expert witness statement, they say your test report or the testing method is wrong. We say no. It is not. We have been supplying for the last 8 years like this. Your representatives are examining this, and we are still sending. We are not being blacklisted. Even ECOLOG is not blacklisted by UN. Or even defendant or claimant are not blacklisted. I'm sorry, are not blacklisted by UN. We say this is our test method. Then I go a step further. Fine, for argument's sake, your test can be accepted. But where is the value? You're just showing some photograph which is not showing what is the temperature of the water which you used, what is the pre-weight, what is the post-weight. You can send one mail saying that, look, I tested, and reject your whole consignment worth $400,000. Just looking at 1 kg without any scientific method. So this is what happened so far as this testing. Your Honor, should I cross this and get into so far as testing is concerned?
Well, it's your opening, Mr. Dinesh. Whatever you want to tell me about is entirely up to you.
Yeah, Your Honor, I was reading something, so I thought
I was looking at I was trying to find the report, so I was trying to follow it in the report.
Yes, that will be unraveled when we look at the expert opinion, and my learned friend would be in a better position to explain it. And so far as this is what happened, then I'll just start from where I stopped. After this testing, they said in July 23rd, they said, fine, we can re-export. The earlier stand was that we can't do that, UN doesn't permit. And 24th July, they said, fine, we can re-export the goods to you, but you have to get an import confirmation certificate from the Dubai authorities, UAE authorities. This is Ajman, not Dubai, this is Ajman. So UAE, you have to get a certificate from Ajman municipal authorities for import confirmation certificate. We said, fine, we can get you the import certificate. Then this happened in 24th. The initial test was on 9th of February, no, sorry, on 5th of February. This process took place, this multiple exchanges of mail, and we were hoping, and there was not a single correspondence saying that your product was rejected by UN. Not a single piece of communication from UN saying that your products are rejected. And these are all, and the expiry of all these goods were in 2020. It is edible, worthy of human consumption, and there is no question of quality of the products is concerned. The only issue was the glazing percentage, which can be, it's a matter of adjustment, or they say some packets contain certain other species. That is the whole claim. And they reject our entire goods consignments. And they are not making payments where they are liable to make the payment within 60 days. They are not doing that. Then 23rd of July, they said, okay, fine, you bring the export confirmation certificate. We run frantically. We talked to them, then said, okay, we'll give you 24 hours time to bring the export confirmation certificate. Then they say, okay, we'll give you time till 1st of August, only 6 days. Then they say, no, the final time which we are going to give is 8th of August 2019, not a day more than that. We said, look, from 8th, our Eid holiday starts. Our officers in municipality are all on holiday. So 8th to 15, we can't do anything. So you can't keep a deadline of 8th of August. Give us more time. We are ready to bring the confirmation certificate. They said, sorry, we started the process of destruction, disposal, and that is an irreversible process that they said. And 2015 and 15, we produced this export confirmation certificate. They said, sorry, we can't help you. We are not in a process to send you back the goods because it is an irreversible process. We don't understand what is this irreversible process of an edible community. And I hope that as per we are all for food security, No person, even UN also, will not destruct or will not dispose in edible food commodity in this era of poverty straight away. And there is a separate mechanism under UN whenever a food export or a supply to UN mission is rejected. There is a procedure to be followed. Even if you go for a destruction, disposal, there is a procedure to be followed. It is not like somebody's wish as something is destroyed. Or of course, UN representative should be there. There should be a notice to the party because I'm the owner of the goods. The seller is the owner of the goods. That is most important. I'm an unpaid seller. I've not been paid. So I am the owner of the goods. So somebody can dispose of my goods without paying a penny and say that, look, it has been rejected by showing a few emails. Then what happens is, in August, then ultimately we have internal mails which shows the one of the witnesses, Mr. Alexander, he says, of course, there are non-claimed receipts, non-confirmation receipts. Prepare a disposal certificate according to the non-confirmation report. So that means you are cutting the size, cutting the legs as per the size of the court. You prepare a non-disposal certificate as per the non-confirmation reports. And finally, and most interestingly, according to their own admission, no UN representative was present at the time of disposal, and they dispose in the month of October 14 to be precise. October 14, they dispose. So what was this grave alacrity which they have shown in July 14, saying that you can't be given a single day more, and beyond August 8, you can't be given a single day more, single hour more, and destroying it after three months, July, August, September, October. They're destroying it. Even there are correspondence to the effect that they were in the process of destruction in the month of September. And what is this great
disposal? Mr. Dinesh, what was your client doing during this time? Did you, after your client was told that the process had commenced, what did you do? What did your client do? Did your client say, no, stop, we want to come and get it? Or what did you do?
We said, please re-export at our cost, And interestingly, I saw certain disposal pictures. This disposal pictures is only dumping it somewhere. They have produced disposal pictures, dumping it somewhere and just setting it on fire. Of course, they have done it. And interestingly, the cost they have asked for the disposal expenditure is a fraction of course, I can prove it. It's a fraction of re-exporting shipping freight. They have asking for huge amount of money for disposal, and the total sending it back to UAE won't be a fraction of this disposal expenditure.
Is there any evidence of the value of the goods at the time they were destroyed when you say they should have been returned?
Yes, value, because that they admit that it is as per the expiry date. There is not a single communication values as per the purchase order. And interestingly, not a single document.
So it was the same. You say the value of the goods that were not in accordance with the specification was the same as the price.
I'm precisely. I'm going to answer this question. In this case, non-confirmation report of so many goods gives a picture, and they produced a disposal certificate by ECOLOG, the defendant, that gives a different picture. Actual disposal certificate, this is a very important aspect of this case. The actual disposal certificate which they have given to us shows a different color, because different picture altogether, different weight, different product, because what they claim to be of inconsistent or non-compliant product is not what they destroyed, which is not, or whatever they have shown in the non-confirmation report is not whatever they have destroyed. And the products are with them. I can show from the disposal certificate itself that that is not the goods which are non-compliant according to them, only their own records. And we requested them. Then they said, look, we are adjusting your price. We are giving you a debit note. And these many goods out of 1 million 21,000 dirhams, we got only about 30,000 dirhams. They set off the entire amount of money, saying that you send us the bad product. So that is the claim. And they say, how can they do it? I'm the owner of the goods. They can do this process giving me notice, giving me at least some semblance of evidence saying that, look, these are the products which you sent, wrong products. And interestingly, they say a DNA test was conducted. DNA test was conducted. They sent 3 specimens to Hamper from Central African Republic. And there is no disposal at all in Central African Republic. Kindly note this point. They sent samples from Central African Republic. There is not a single piece of paper showing that the goods were destroyed. That's in Central African Republic. And they say we destroyed the goods are from Mali. Not a single document showing that the products supplied to Mali is of a different character. And they conducted this glaze test in Mali, 2 countries far away. And they conducted this glaze test in Mali. And they said, look, your glaze percentage varies so far as the product in Central African Republic is concerned. And they adjusted the entire glaze percentage. So you are only showing only a few kgs, few kilos, maybe grams, 500 grams out of a huge consignment. And 500 grams they test. And they said, look, there is some variance. And the same product we have been supplying to them for the last 4 years. And interestingly, during this dispute goes on, same people who placed orders on us, they again placed order, tendered. They again invited tender from us for the same product. And there were correspondence back and forth that particular, it is not one of the mails, or it is not just a mistake. The same people who have been dealing with us, they corresponded with us in the month of March. The glaze issue happened in the month of February, and March they started corresponding to us saying that, look, we need more products. Then immediately they realize, look, then Mr. Alexander comes into picture and say that, look, you don't correspond with these people because legal team will start corresponding. So the entire purchase department, the significance is the entire purchase department is unaware of this glaze test, DNA test. Interestingly, or most importantly, it is for the purchase department should know if they bought something that is not as per the complaints, or not as per the labeling. There is an issue with the end customer, that is UN. And my respectful submission is that, assuming for a moment that we send certain wrong products, only few kgs, conducted a glaze test of few grams, and they don't make the payment of $400,000 for this. They don't pay. And they conduct a test somewhere in Mali, and they don't pay for the goods which we send to Central African Republic. And they conduct a test and they consumed it. Interestingly, they said UN consumed it. UN missions, and they have a standard policy. Central African Republic, there is no destruction. There is no proof of disposal. They adjusted only the glazing issue. And the very same product, they adjust only the glazing, not saying that it is not worthy of consumption. So they did not destroy, they don't have a case that they destroyed or disposed the products at Central African CAR Republic, and they talk about Mali. And they don't have a clear case. And most important aspect, of course, there are many important aspects, but here it is a very interesting thing has also happened. They said they went for a risk purchase. They went for a risk purchase because we could not deliver the goods as per our representation. This is happening in the year 2019. The contract and the working of the contract or execution of the contract happens during the period of 2018 to 19. And the risk purchase, they produced documents of invoices of 2014, 2018. So it's quite a wonder how a person who claims that I had to go for a risk purchase because you did not deliver the goods as per the specifications, And to substantiate their counterclaim, they produce certain documents of 2014 invoice, 2018 invoice. That shows, of course, they said I should not have used the word fraud or unjust or dishonesty, etc. But what is this, Your Honor? How can you come to a risk purchase and substantiate your claim of 2014 and 18 document for the purpose of the alleged risk purchase, which you, according to you, happened in the month of 2000, in the year 2019? How can you rely on this? How can somebody produce these sort of documents in a court? So it shows that there is a lot of hanky-panky here. They just wanted to avoid the payment at any rate. We don't know. They are a big supplier. We don't know their contractual terms with the UN. They have many claimants like parties. They might be getting goods from different parties. We don't know what transpired between UN officers. They say it is, and the important aspect is all these goods, entire goods are good for human consumption, and the expiry date of all these goods are in the year 2020, whereas the disposal took place according to them in the year 2019. So we had enough time to take it back at our cost. They did not do that, and they were hurrying it. For just burning it, they said, look, and without even representative of UN. Of course, in certain region, I did some research on this in Somalia and other areas where our internal strife is very high, where at the time of disposal, if it is happening, the UN representative may not be in a position to participate because of the security reasons. Here, there is no such case. UN representative mandatorily as per FAO standard, because UN always look for food security. You can dispose of certain goods which are not worthy of human consumption. Then the secondary stages, you can make it as an animal feed. Then even if it is not microbiological infection or something, and only you are supposed to make a food waste, burn it out. UN doesn't talk about disposal of edible goods. UN can never do that, or any sensible or any reasonable person can do that. And this is a simple, fair practice in trade. Because they took it very lightly, they did not pay a penny to me. So they can do this. I'm an unpaid seller. And they very casually took the entire issue because they have not paid a penny to me. So they did it. They said, okay, your goods are not worthy enough. We are sending it back. We are disposing off. We got this certificate from the UN. Yes, that's the end of it. You don't have a claim. This is exactly happened in this case, Your Honor. I'm done so far as opening statement is concerned, Your Honor.
Right, thank you. Ms. Walker, do you wish to make an opening statement now?
I'm sorry.
If I may, please, Judge, yes. I'm hoping that my teams, when I unmute, will catch up with me. And if there's any issues with hearing me, please do let me know. I hope to be very brief. I do note that Mr. Dinesh did say he was going to make brief submissions, and we've gone to nearly an hour, but I hope if I can, to assist the court, I will keep this as brief as possible. I, of course, do not wish in any way to repeat the written opening submissions that I've already provided. And as Mr. Dinesh has made reference to, we have got a bundle of some significant weight for a matter that, as you will appreciate during my submissions, we say is a very straightforward matter. I'd just like to first start, if I may, with a point, Judge, that you referred to, which was about the second defendant, which I was very pleased that was an issue that was brought up. As the court will be well aware, this was referred to in both the defence and counterclaim in the reply of the defendants and also in the written opening submissions. It remains still, even after, with respect to Mr. Dinesh's submissions, entirely unclear as to how the second defendant is a relevant party to these proceedings at all. As Judge, you referred to the purchase order at 01 to 14, the contractual party is the first defendant. It's not the second defendant, and I would be seeking a strikeout of the second defendant to the proceedings from the get-go. Even after answering some of your detailed questions, we still didn't receive an answer as to why the second defendant is a party. This is a straightforward matter. The claimant either provided the correct goods in accordance with the contract or they did not. The claimant also seems to ignore the fact that there are two missions. I heard a number of references that were being overlapped from some of the submissions I heard from Mrs. Dinesh, that we need to remember one is MINUSMA, one is MINUSCA. This matter concerns MINUSMA as set out at paragraphs 12 and 14 of my opening submissions. The set-off that occurred was in relation to MINUSCA. So if I can just set out this distinction from the get-go, I think it allows us to be a little bit clearer about the two different missions that we're addressing. Claimant has instead done is use as many ways they could think of to deflect from the central matter in hand. The question is, what did they provide? Did it comply with the supply contract? At each element of this case, whether it be through the pleadings, the witness statements or the skeleton arguments, for want of a better term, and I do apologise for being flippant, but the claimants use what we would normally call a red herring, and I know of course the subject matter of this case is fish, but they're using red herrings in order to simply make this a more complex matter than it is, in order to try and move away from as we've actually, with respect to Mr. Dinesh, heard from his, if we give a scenario we didn't provide the correct goods, well, we're in a situation where the correct goods weren't provided. This is also a case where both parties entered into a contract of equal bargaining power, but also equal knowledge as to the context and purpose of the supply contract. I counted 4 references by Mr. Dinesh to the fact that we are a large organisation. So is the claimant. So I would like to just make a clarification there that we're not looking at a Samson and Goliath type matter here. The claimant also seems to be under some illusion that the defendant has only brought the defence and counterclaim due to the claimant having brought this claim. But as we can see expressly in the documents, the points actually raised by the defendant are not in any way new. In fact, the points were raised expressly in email communication from the defendant's witness, Mr. Gelov, who we will hear from later today, to the claimant. And if I may, Judge, refer you, if you would rather take a note of these pages or take you to the bundle itself, it's 05386, which, to help if you're using a PDF, is page 700 of the bundle. Sorry, Judge, you're just on mute.
Sorry, it was 05. I just missed the number.
05386. And if you're using a PDF, it's 700 of the PDF.
Yes. Right. And what is that 05386?
What it is it's an email communication from Mr. Gelov setting out the concerns and complaints, which are exactly the concerns and complaints that, of course, have been set out in the defence. And that's dated the 21st of August 2019. So over 2 years before the defence and counterclaim. And then we have, in addition to that, a more fully set out response by the the first defendant at 05-414 or page 728 of the bundle.
So those numbers again. Sorry, Ms. Walker.
05-414
yes.
or 728 of the PDF. And this is an email on the 1st of November 2019, fully setting out the position of the first defendant. And it's the same position that was set out in the defence and counterclaim. With respect to Mr. Dinesh, I was a little bit concerned by some of the submissions he made, because he seemed to become an expert on various different points in this case, and with respect pleaded some evidence, which of course, as advocates, we at least avoid to do, but with respect we should do.
Right. Well, Ms. Walker, you can safely assume that I will be deciding this case on the basis of the evidence, not the submissions.
Thank you very much, Judge. Given the burden placed before the claimant to demonstrate that monies were actually owed as a result of conforming with the supply contract, which of course the defendant denies, the defendant respectfully submits that an adverse inference should be drawn from the absence of a witness who might have been called and who might be expected to have material evidence to give. as I've referred to in my opening submissions, my written submissions, and in relation to a case from the UK Supreme Court of a FZE, the court should be free to draw or decline to draw inferences using their common sense without the need to consult law books when doing so. And whether a failure to give evidence was significant would depend entirely on the context and particular circumstances, including, for example, whether the witness was available to give evidence, what evidence it was reasonable to expect they would have been able to give, what other evidence there was on those points, and the significance of the points in the context of the case. The defendants respectfully submit that the claimant has not discharged its burden of proof in relation to actually the heart of this dispute, which is whether the fish species provided was in accordance with the supply contract, the glazing percentage was correct, and whether mislabelling had in fact occurred. Now, in contrast, the defendant has produced an expert evidence in the form of Dr. Werner Nader, who opines on the issues of excessive glazing and mislabelling in the goods received by the claimant, and that's at 7-1 or page 2551 of the bundle. Now, I do not wish in any way to explain Dr. Nader's report. I'm not an expert in relation to the matter of fish coding and glazing, but he will be giving evidence. But I would like to summarise some of the key points that he makes. He is able to opine that the claimant had mislabelled the goods by stating an incorrect glaze content and different lot numbers, and had therefore breached the UN standard product specifications. He says this at 7-2. Furthermore, the claimant was acting in gross violation of basic rules of food safety management systems, which the claimant is certified for, and he says that at 7-3. Furthermore, the claimant had mislabelled the frozen red snapper products as the origin was stated to be India FAO Zone 51, which, as he opines, cannot be correct given that red snapper is not native in that zone. They're found in Zone 31, and that is at 7-4. And finally, that the DNA barcoding was found to not be cod, haddock, or plaice, but instead Pacific pollock, demonstrating that the claimant had in fact falsely labelled the fish species and therefore was charging an increased amount for those items of fish. Now, I did notice during Mr. Dinesh's opening submissions that he referred to the FAO standards. Now, this is not something that has been entered into evidence by the claimant. It is referred to, however, by the expert of the defendants. Now, the claimant seems to be relying upon it potentially as a point, but it's without expert evidence. And I just wanted to flag that that was an issue that I noted during my learned friend's opening. In addition to the lack of expert witness on the part of the claimant, it's also noted that another key individual appears in a significant proportion of the correspondence between the parties, which is a Mr. George Vagese, who is the general manager of the claimant. However, he is also not appearing on behalf of the claimant. Now, I'd like to just make some brief references, if I may, to some of the legal authorities that are relied upon by the claimant, and in order to set out the defendant's perspective in relation to those. I hope I'm keeping well to time. I've noticed I've done 10 minutes so far. I will be about another 10 minutes, if I may. First, I'd like to address the British Westinghouse Electric and Manufacturing and Underground Electric Railways Company of London, 1912. Now, this is a little bit misleading in the index. It's not actually the case. It's an authority by Andrew Dyson, seemingly dated 2012. Now, of course, judges, as you are aware, and I would not want to make a statement that over-eggs the point, but it's an academic opinion. And of course, it has less binding nature upon this court and is not a case and is not an authority that actually has been included in the bundle to be relied upon. What is binding is the fact that British Westinghouse Electric is still an authority under English law of positive judicial consideration. Now, in the article, it demonstrates that it's well established that losses must have been factually caused by the defendant's breach to be recoverable. What we have here is losses which were factually caused by the claimant's own breach, which would therefore not be recoverable. Secondly, turning to photo production and secure record transport, parties to a contract, when they've bargained on equal terms, which of course, as I referred to earlier on in my opening submissions, is the matter here, should be at liberty to apportion liability in the contract as they see fit, and that the wording of the exclusion clause in the case of photo production was adequate to exclude liability for what occurred. Furthermore, photo production held that although the breach might have been fundamental in nature, it did not render the terms in the contract completely unenforceable. The scope of the exclusion is, of course, then determined by examining the construction of the contract. And since photo production, there has been reams and reams of authorities that have come out of the English courts, which has explained and developed the importance of the construction of a contract and the intention of the parties. Now, it's not the argument, and never has been by the defendants, that the terms of the contract were completely unenforceable. Simply that the claimant breached the contract and is now attempting to rely upon that breach to obtain a gain. As per photo production, both parties in this case expressly incorporated into the contract that there would be elements in addition to the local purchase order, which you've already been taken to. Now, Judge, if I may, there is a page reference I would like to take you to, and if you could have it on the screen, it's 06-30, 1880 of the PDF. I'm not sure whether you have hard copy or whether you've got soft copy, so please do let me know. Soft copy, okay. You're on mute, but I look red, soft copy. It's 1880 of the PDF. Now you can see this is email communication from the first defendant to the claimant.
Said it was 06-330, did you?
06-30, 30.
Right, thank you.
Or 1880 of the PDF. And you can see this is a document which is dated November the 12th, 2018. Now this attaches the PO 8000029571. So we can see that when we're looking at this document, this is a document that both is attaching the procedural order and contains express detail within it. Now, if I can take you to the bottom of 0630, which is where it says important note. It's just below, please forward the draft bill of lading.
Yes.
And it states here, the UN specification sheets are sent for your reference during the pre-order, and items you are confirmed are ensured to be, in capitals, fully compliant. Any item confirmed by vendor to be fully compliant and rejected on the later stage, vendor will be requested to take full liability. Now, as I've made reference to, this also, of course, attach the procedural order. I don't want to take you to 0114 again, Judge, because we've already got a reference by, apologies.
What do you say that means? Vendor will be requested to take full liability. What does that mean?
Well, that's in the terms that the claimant, Eastfish, would be required to take full liability if it turns out that it's rejected at a later stage.
But perhaps I'll be more specific. What does full liability mean in that context? If the goods are rejected, what does full liability mean?
That they would not be able to be paid for the goods because, of course, they've not complied with their contract.
Right, all right.
And then this is also in addition to clause 5 of the purchase order, Judge, which you referred Mr. Dinesh to earlier on.
Now, while I'm interrupting, this document is November 2008. 2018.
Yes.
So the purchase orders upon which the claimant is suing, they're all 2019 documents, aren't they?
They're 18 and 19.
18 and 19. All right, thank you.
Because also, if we remember in the factual timeline, in 2018, that was also when the claimant purported to be able to demonstrate that samples had been tested in 2018 ahead of deliveries which were occurring in 2019.
Right, thank you.
And as we've already heard in relation to clause 5, Judge, which you addressed earlier on, which provides that the vendor shall remain liable for the goods until the customer has had an opportunity to inspect them at their final delivery destination. So it's very clear in express wording where liability rests and sits with which party at which point. And also, it's very clear about the fact that there is a time gap that if it's, say, later stage, that therefore Eastfish will be responsible for their breach. I also noted in the submissions of the claimant, rather unusually, there's an older authority, if we may call it, in
You've dropped out, Ms. Walker. You've dropped out. I can't hear you. Still can't hear you. No, still no good.
Miss Walker, please sign out and sign back in again.
Rona, will there be a recess in between?
Yes, well, just before we'll have a short recess before your witness is called. Ms. Walker.
Could I check whether I'm heard?
Yes, you are. Thank you.
Right, if we can give my teams a little moment to just heat up. It's a little bit more winding technology up, I find, with Teams occasionally, and hopefully we'll then be back on track. I do apologise. It's virtual hearings are fantastic until technology fails.
Yes, indeed. You dropped out at just the stage you were going to refer us to another authority.
Robinson and Harmon.
Yes. Yep.
Thank you, Judge. And now it's, as I'm sure we're all aware, it's a rather old authority, and is normally an authority that's referred to in undergraduate textbooks. But I would like to address it, given it has been used as an authority which the claimant relies upon. And it was held by Park B that where a party sustains loss by reason of a breach of contract, he is, so far as money can do it, to be placed in the same situation with respect to damages as if the contract had been performed. Alderson B states that where a person makes a contract and breaks it, he must pay the whole damage sustained. And this is exactly what the defendant, in fact, is seeking in relation to their counterclaim. The claimant has made some very serious allegations, including in the skeleton argument, where they state, in fact, in the opening sentence, that the claims arise out of the illegal rejection of the goods. And I also noted the reference by Ms. Nanesh to hanky-panky, which has occurred on the part of the defendants. Which, as the defendant states, the illegal rejection, as the claimant refers to it, is simply the rejection due to non-compliance. The claimant also goes on to paragraph 28 of the skeleton argument to contest the authority of the lab report. However, this is without any form of expert evidence on their part, and even more alarmingly, particularly from legal representatives, without providing evidence to justify such a statement, paragraph 47 of the skeleton argument, that the defendants have colluded and concocted to make a report for the alleged rejection and disposal. The defendant has, as I've made reference to, provided an expert witness from Eurofins, who in fact the claimant itself states they used, and that is at 051128 or 1442 of the PDF. And this is a report dated 2018. What is interesting is the fact that Mr. Nader in his expert report actually queries the validity of the claimant's Eurofins report, and that is at 7-7 of his report. The claimant has chosen to not adduce any expert evidence to explain the lack of information in relation to the report, and the suggestion that a nexus between the defendants and Eurofins shall be viewed judiciously is extremely peculiar given the claimant's own connection with Eurofins. There is also, at paragraph 47 of the claimant skeleton, an accusation that the defendants have failed to produce documents to support payments to Eurofins. I would just like to place a marker that that is actually found at 05-1253 of the bundle, or from a PDF perspective, 1274. Now, we will hear evidence from the factual witnesses in relation to various practical matters which arose in the lead up to the testing of the products. And we'll also hear in evidence, and has been entered into evidence in the bundle, detail concerning the disposal of the non-compliant goods provided by the claimant. I did note Mr. Dinesh's summary of the disposal timeline, which, with respect, was a rather narrow summary, and I've addressed in my written submissions a more full timeline. We also need to remember, in terms of the disposal, that we're dealing with perishable goods, and goods which were under the auspices of the UN and had to comply with UN requirements. And at the point when disposal was authorised, disposal was then in the hands of the local authorities and not, in fact, in the hands of the first defendant. Finally, turning to the Sales of Goods Act, to which both parties, in fact, rely. The claimant refers to section 35, subsection 4 in their submissions. Now, section 35, subsection 4 contains the word also. So therefore, upon the interpretation of the subsection, it cannot be read as a sole subsection. You would need to read section 35.1 and section 35.2. Now, to take you to it in the bundle, Judge, it's at page 2696 or 10-37. Given that it's not possible to read a subsection without also understanding what comes prior to it. Now, if we can see from the wording of subsection 1 of 35.
1037 is not the Sale of Goods Act, I don't think.
Oh,
Sorry, it's 1979. All right, so.
Apologies, I've just taken you straight to the section that I'm referring to. It will commence
So why are we looking at the 1979 Act rather than there's a Sale and Supply of Goods Act 1994. What's that?
So there's the Supply of Goods and Services Act of 1984, but we're looking here at the wording of Sales of Goods Act, which under the Supply of Goods and Services Act, it does say that you can refer to the Sales of Goods Act, particularly for matters as I refer to as section 13 and section 14 as implied terms. Now, from my perspective, I don't believe section 35 applies, but it hasn't been repealed.
So what did the Sale and Supply of Goods Act 1994 do? Because that's in the bundle as well. Does that repeal the previous 19?
I'm just going to go to the bundle index, if I may, because I believe that it's been worded incorrectly. But if I can just be given one moment. So I'm referring to the Sales of Goods Act 1979. The Sale and Supply Goods of 1994 is what it does is it looks at the issue of quality and substitutes it's an amendment. But of course, 1979 is still law that is deemed to be good law. And from my perspective, in terms of what we're looking at, we are looking at the sale of goods, not the supply of goods, but also in relation to the sections that, from the defendant's perspective, they have not been amended or reenacted in that act.
All right. You were referring me to Section 35 of the 1979
Yes,
Act.
indeed, of the 79 Act. I have noted as well that the 1994 Act has not been referred to by the claimant. They've only referred to the 79 Act. My understanding is that they've done it for completeness. I don't believe they're actually referring to any sections. Certainly nothing that's been included in their skeleton argument or their opening submissions. So if I may take you to the 79 Act, which of course is still good law, and then as we're also aware, if we're to give completeness of the legislation in this matter, we also have the 1984 Act, which is the supply of goods and services. But of course, that's not a matter that we need to be concerned about today.
Yes.
So if I can just be given a moment to get my page reference. So section 35. So this is a section that the claimant expressly addresses in their skeleton argument and opening submissions, where they address subsection 4, where it says the buyer is also deemed to have accepted the goods when, after the lapse of a reasonable time, he retains the goods without intimating to the seller that he's rejected them. Now, of course, you can't read that subsection without reading subsection 1 and 2, because it uses the word or, so we would need to make sure we know what 1 and 2 means. Subsection 1 is about when goods are accepted, and subsection 2 is about when goods are delivered. And of course, the matter that we're dealing with here is the point of delivery and them having been not deemed to have been accepted. Now, from the defendant's perspective, we are within 35 subsection 2, because what we have here is goods that were delivered that were not previously examined as a whole, because of course they couldn't be. They were examined on the part of a pre-inspection in relation to the labels on the external. They couldn't actually inspect the actual good until you open them up, you deglaze them, you then are able to then assess the DNA coding. Section 20 of the Sales of Goods Act, which the claimant relies upon, which is at page 10-30 or 2689 of the PDF. Is in relation to the passing of risk. Now, this isn't a legal argument that's been raised by the claimant, so it's unclear actually as to the relevance of section 20 subsection 3, which has been submitted in the skeleton argument. Moving on to then what is of note in relation to this act is section 13 subsection 1, which concerns the implied term that goods should correspond with their description, which Mr. Dinesh referred to in his oral opening earlier, and also section 14 subsection 1, which concerns the implied term that goods should be of satisfactory quality. Now, of course, it is interesting that they were not referred to at any point during the written openings, but there was a reference to description by Mr. Dinesh. Now, these sections are relevant to the claim at hand. Finally, the claimant makes a number of references to the fact that the first defendant sought an alternative supplier in their written submissions. They don't, however, I've noted, make a reference to this in their oral opening today. But the point is still and remains unclear to the first defendant as to where the issue is in relation to seeking an alternative supplier. The claimant was aware that the claimant's goods were deemed to be rejected and that they were disposed of, and therefore, as a factual and legal common sense connection, a new supplier was going to be needed in order to supply the UN, which the claimant was always aware was the end point and purpose of the supply contract. So unless I can assist you further, Judge, that concludes my brief opening. And I apologise for my technical interlude in the middle.
These things happen, Ms. Walker. I've had trouble myself, and it may still occur. So let's see.
Indeed, fingers crossed I don't tempt.
We've been going for about an hour and a half. This might be a convenient time for a break. Why don't we break for 10 minutes, and then Mr. Dinesh, you'll call your first witness, and that will be, is Is that Mr. Renaud or Mr. Sadir? I can't hear you, Mr. Dinesh.
I apologize, I was on mute. Of course, two witnesses are there, Renu as well, both of them are ready.
Yes, well, which one will you call first?
Mr. Renu.
All right, and Mr. Sadir won't be watching his evidence, will he?
Mr. Sudhir, Mr. Sudhir is not supposed to watch the evidence, and
you'll ensure that happens.
Sure, and instruct the clients accordingly.
Yes, all right.
May I just check? Is it Mrs. Renugarish or Mr.?
Mrs. Renu Ghosh.
It is Mrs. Okay, I just want to check I've got the correct title. Thank you.
I think I want to introduce that error, of which I
Your Honor, I just want to, of course, this is not the time to say something, but I just want to make one aspect so clear out of certain misconceptions. There are two Eurofins here. One is Eurofins Hamburg, and the Eurofins which I referred is Eurofin India. There are two different companies. Then the second aspect which I would like to point out is that the expenses of Eurofin was not the question. The purchase or the payment paid to the disposal of the goods, not the amount paid to Eurofins, which you suggested that there are records to suggest that this is the amount paid to Eurofins. But that is not the amount. The supporting document receipts for disposal is the issue which I raised. I think Ms. Emma has slightly misconceived it. So I just want to clarify that.
Thank you. Well, we've now reached almost half past the hour. Let's resume at 20 to the hour, whatever the hour is, wherever you are. And then we'll go for about another hour and a half and then have a longer break around a bit after 5 p.m. in Dubai. We'll have a longer break. So, Mr. Dinesh, that'll suit you. You're in the UAE, Mr. Dinesh?
I'm in the UAE.
Yes, all right. Well, that'll give you a chance to get some lunch and perhaps either some late breakfast or some early brunch for you, Ms. Walker.
Yes. Thank you,
Judge. Overage, though we wish to have this good lunch, we can't have it because of diabetes, sugar, and all kinds of stuff. I mean, cholesterol.
All right. Well, just leave the links open, but perhaps turn your screens off and microphones off, and we'll resume in 10 minutes. Thank you.
Yes.
Yes, all right. Well, we're ready to resume then. Mr. Dinesh, would you like to call your first witness?
Just check. Miss Emma. Miss Emma, I'm sorry. You may face difficulty with my witness. So basically the first is English. Of course, he understands English. Second, while you speak, I request you to speak a bit slowly because there will be an issue of accent. So because he may be facing it slightly tough to understand the accent. Though you gave us the language, we all taught by you English.
Yes, all right. Well,
India got English from British, so that's what I was referring to.
Right.
Witness, where is witness? Link. Have you sent the link?
Link is there.
I'm instructed to say that witness joined. Sorry for keep you waiting. I don't know, some technical glitches. Just see that. Coordinate. Should I administer the oath or the court officer will administer the oath?
Yes, Miss Jirish, can you hear us?
Yes,
Yes, okay. Would you please state your full name and occupation for the record?
okay,
Miss
good.
Jirish,
Yes,
can you please state your full name and occupation for the record?
uh, do I have to write it somewhere?
No, just state it, just say it.
Okay, okay. I'm Renu Girish.
And what is your occupation?
I'm a quality assurance manager.
Thank you. Will you be swearing or affirming today?
Sorry,
Are you going to swear on a holy book or are you going to affirm, like promise?
I have my holy book with me.
Okay, please place your hand on your holy book
Yes.
and repeat after me.
Okay.
I swear by Almighty God,
I swear
by Almighty God,
by Almighty God
to say the truth,
to say the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Thank you.
May I begin? Please. Thank you. Once again, Ms. Renu, can you just tell your full name for the record?
I am Renu Girish. Okay.
Yes. What is your qualification?
I am BFSC, that is Fisheries Graduation. BFSC,
Bachelor of Fisheries.
Bachelor of Fishery Science.
Yes, Fishery Science. How long you have been in this profession?
For the last 30 years.
Are you an expert in the fishery science?
Yes, with my experience, I think I am the expert.
You have your witness statement. Do you have your witness statement?
Yes, I have.
Kindly refer to your witness statement, and that is at page 061 to 069. Is that correct?
Yes.
And you have also exhibited documents, which is at 6100683. Is that correct?
Can you repeat the number?
Yes.
Please.
You have produced documents along with your witness statement, and that is at page 0610 to 0683. Is that correct?
Correct.
Kindly come to your witness statement at page 069, which is dated 10/2/2022. Is that correct?
Yes.
Kindly see the
Yes.
signature at page 069. Is that your signature?
Yes.
Thank you. No further questions, Your Honor.
Ms. Walker, cross-examination.
Thank you. Good morning, Mrs. Girish.
Good morning.
I will speak as slowly as possible. If at any point you don't hear my question, please do interrupt me and ask me to repeat.
Okay, thank you.
Okay.
Thank you.
I will also, after every question, take a pause so that you can have time to answer the questions I put to you.
Okay.
And may I also ask, do you have a soft copy of the bundle, or do you have a hard copy of the bundle? Because there are going to be a number of pages I'm going to be asking you to look at.
There is some interruption. I cannot clear. It's not clear. The voice is not clear.
Do you have a PDF version of the bundle or a hard copy of the bundle?
The PDF version.
So I will take you to the PDF numbers.
Okay.
Okay, thank you. Now, Mrs. Girish, you were dealing with the quality assurance of the claimant's products, weren't you? And in your role, you monitor the policy, strategy, and testing methodology to meet regulatory authority compliance regarding the goods.
Okay.
You don't, in your witness statement,
Ms. Renu, don't
Yes.
say yeah, don't say yeah. You please say yes or no.
Okay.
Yes. Thank you.
Okay, thank you.
I'll continue. You don't state that you have any qualifications in relation to quality control, do you?
Qualification, you mean?
Yes, in relation to quality control.
Yes. I am a fisheries graduate.
Could you take me to where in your witness statement you state that you have a qualification in relation to quality control?
Okay.
Which paragraph number is it?
That is the first paragraph.
Where does it state that you have a qualification in quality control?
Do I have to read this?
If you could just tell me the words that state you have a qualification in quality control.
I was working for both the companies as quality assurance manager. That is a sentence.
That's not the same though, is it, as saying you have a qualification? It simply says that you work as.
Okay.
So could you tell me where it states in the paragraph that you have a qualification in relation to quality control? I don't think you'll be able to find it, Mrs. Girish, because it doesn't say it.
Okay.
And you also don't state in your witness statement that you have any qualifications in relation to testing of fish, do you?
It's not explained here.
It's not. So if I can ask now, if on your PDF bundle, you can go to page 2599, and for the bundle reference, it's 7-49. And please let me know when you've got there.
Sorry, can you please repeat the number?
Of course, of the PDF, it's 2599. For the bundle reference, it's 7-49.
Okay.
Do you have that in front of you?
Sorry.
Do you have it in front of you?
Yes.
Okay, so if we go to the About Us section, do you agree that this is a copy of East Fish's website?
Yes.
Yes. And we can see under About Us, in the second paragraph,
Okay.
high standards of quality that are ensured and monitored through the highly effective FSSC IS0 22000 2005 HACCP EU and USDA quality system. Do you agree that's what it says?
Yes.
Okay, thank you. And if we go below to our story, the second screenshot.
Sorry.
You see our story, the second screenshot.
Okay.
Yeah. It states, handled with the utmost care and hygiene, our products had received factory approval and accreditations, including FSSC, ISO 22000, 2005, HACCP, EU and USDA. Do you agree that's what it says?
Yes.
EastFIS advertises that its certification is FSSC ISC 22000, doesn't it?
Yes.
It advertises that it complies with international quality standards, your
Yes.
role being quality assurance.
Yes.
Thank you. EastFish were required to be audited in advance of receiving their FSSC ISO 22000 standard, weren't they?
Can you please repeat the question?
Of course, of course. EastFish were required to be audited in advance of receiving their FSC ISO 22000 standard.
EastFish?
Were required to be audited.
Audited. Yes, it's audited.
Can I ask you now, please, to turn to paragraph 7 of your witness statement?
Yes.
And can you see at the opening sentence, it says the claimant had at all times complied with the UN standard specifications.
Yes.
Do you agree that EastFish knew it had to comply with the specifications?
Yes. Always
Thank
complete.
Thank you. If I may now ask you to turn to page 2448 of the PDF bundle, and for bundle reference, it's 6598.
Sorry, Ms. Walker, what was that page number again? The bundle reference?
The bundle is 06598.
Thank you.
And for Mrs. Garish, it's 2448 of the bundle. Now, Mrs. Garish, if you let me know when you're there, we can all be on the same page.
All right.
Thank you. So as you can see, this is an email from the UN to ECOLOG on the 5th of February, setting out the concerns raised in relation to the products provided by EastFish. Do you agree with that
Yes.
email being in front of you? Thank you very much. If I can ask you now to turn, and I do apologise if some of my bundle references are backwards and forwards, there was a lot of duplication, a lot of repeat documents in the bundle. So as it was a moving target, you might find that you're jumping about. So I do apologise. If I can ask you now, Mrs. Garish, to turn to PDF 1868. And for the purposes of the trial bundle, it's 6-18.
PT?
6-18.
18. Thank you.
1868 of the PDF.
Okay.
Thank you very much. And you can see that this is an email chain of
Yes.
the 7th of February.
Yes.
Thank you. Now, ECOLOG emailed Eastfish stating, as we spoke on the phone, we have serious issues with your items in our missions. After the audit and internal tests conducted from our client, there is difference in glazing percentage from the declared percentage in the label. As of now, this might trigger serious dispute with our client. And if I may add, the client you agree is the UN.
You're asking about whether I see the mail, or you are asking, I couldn't get you.
See the email. I ask if you see the email first. Are you following where I'm reading?
Okay.
I'm not, I'm afraid. Which page are you reading
Apologies,
from?
Judge.
Reading from page 18.
So 0618 at the very bottom, we see it's an email chain. We see the 7th of February, it's an email from ECOLOG.
Yes, I've got
And
it.
it says, as we spoke on the phone.
Yep.
Okay.
Thank you. And then it goes on to say, if we fail to prove the declared glaze in the label is correct, our client can blacklist Eastfish as source of frozen fish items. Also, we are facing some other requirements from our client. You agree it says that, Mrs. Girish?
I agree about what is written in this mail, but I don't agree with the what do you call out of spec labeling.
Well, we're going to go on to that in a moment, I assure you. We can then see, Mrs. Girish, that if we go up the page on 0618, we have your response, don't we, on the 7th of February?
Which page? Sorry.
On the same page, but you need to go further up. It's an email chain, so it's going slightly backwards.
Okay.
So on 1868, we can see your email of the 7th of February.
Yes.
If you've got that in front of you, it says, please find the in-house glaze checking as per our SOP.
Yeah. Yes.
Yeah. So you therefore had communications with ECOLOG in relation to the concerns raised by the UN as of the 7th of February, didn't you?
Yes.
I ask you now, please, to turn to the page before, which is 1867, bundle reference 617.
Okay.
And you can see here at 6-17 that there are additional questions put to Eastfish, which you then subsequently answered at 6-16 PDF 1866. So it's an email chain. We're having to go backwards on the pages, as you'll see. So if you've seen the questions, now the answers that you give are at 6-16 PDF 1866. Have you found that?
Yes.
Thank you. And that's dated the 12th of February 2019, isn't it? The date of that email is the 12th of February 2019.
Yes.
Now may I ask if you can turn to PDF 283. And for the bundle reference, it's 1-264.
283.
283 of the PDF, 1-264 of the bundle.
Okay.
Now, can you see this is an email from the UN to ECOLOG on the 14th of February?
Yes.
Thank you. And you can see here it sets out further concerns in relation to the products that were provided by Eastfish. Now, as you've already mentioned, it's the 14th of February. We've just seen the email of the 7th of February.
Yeah.
And in this email, you can see it's from a Jose Viana of the UN.
Sorry?
Jose Viana. You can see this email is from Jose Viana of the UN.
Ah, yes.
Yes, thank you. And in this email, it confirms that due to misleading labelling on net weight, glazing contents, species, and producing source catch area, all products supplied by Eastfish are on QA hold.
Yes.
And for current stocks, ECOLOG is requested to send urgently sample to Eurofins for testing.
Yes.
Yes. If we go to the page of 234 of the bundle, again, I apologise for the jumping about, but the documents aren't in chronological order, and the bundle reference is 1-215. So 234 of the PDF, 1-215 of the bundle.
Okay.
Yeah, you've got that in front of you?
Okay.
Wonderful, thank you very much. So we can see in relation to this email that this was forwarded directly to you, wasn't it? You received it from Sadia on the 14th of February. It says, attention Renew, please note below mail from ECOLOG and reply soon.
Yes.
Yes. Go down the page of 215, we can see what the email says that you're being asked to address. And it says 2 different labels for the same lot of item 186 shipped in UN missions. One is the lot we have purchased from you and shipped in Mali, and the other one is what we received from UN from another UN mission, which is stated as packed by you. As you will see, there are contradictory information when you are packer and exporter, and different when you are packer with different exporter. Please make sure that you provide all the details, because as informed, this is an issue with UNHQ, and they have different sample from different items that are packed by you to confirm glazing and also DNA species of the fish. Do you agree it states that?
Can you please repeat your question?
Agree that I've just read out the contents of that email that was sent to you.
Okay.
Okay, do you agree? Is that a yes? You agree that I've just read out what that email says that you received on the 14th of February?
Okay. Do you want?
Is that a yes? Do you agree with what I've just read out, that you received this email?
Yes.
On the 14th?
Yeah.
Thank you very much. Wonderful, thank you. Now, ECOLOG prepared the pre-inspection report, didn't they?
Okay.
Do you agree that ECOLOG prepared the pre-inspection report, or do you not agree?
ECOLOG QC come to the delivery station. They will check the product. They will write down the pre-inspection. Then they give us the format. We enter it in that format and send back to their QC.
Thank you. Now, the pre-inspection, when you say they inspect the product, that consists, doesn't it, of looking at the packaging, the label, the temperature, and the weight.
Sorry?
You mentioned that there is inspection of the product. Do
Yes.
you agree the inspection consists of looking at the packaging,
Yes.
the label,
Yes.
the temperature, and the weight?
Yes. Yes. And also they check the other quality parameters also.
What they don't, however, do, though, do they, is they don't test the DNA coding by opening the packaging.
No, not DNA, but they inspect the product.
But they don't open the packaging to inspect physically the product, do they?
They will open the packet to check the quality and the temperature of the product. Without opening, they cannot inspect.
But what they can't do is check that what they have inside the product is the same as what's stated on the label without testing the product itself.
Not the species, but all the other parameters can be checked by opening the packed cartons.
whether there's excess glazing, however, can they? Because it's not being deglazed.
No, they used to deglaze in our unit. They used to do that.
When you say they used to, who's they?
ECOLOG QC, one lady called Desta and another person called Steven. They used to come and they check the product. They check the weight, they deglaze it, and they check the label.
But when they are deglazing, they're simply checking that the deglazing at that point is what's stated on the label, but it's not a thorough examination because it's a pre-inspection, isn't it?
It's pre-inspection, but it's a thorough check. It's a thorough check, they weigh the product, frozen product, they deglaze it, then again take the weight, calculate the glaze, they make the chart, they all do this.
Can I ask where you state in your witness statement that it is a thorough check?
It's a thorough check, but excluding DNA analysis.
Can I ask
all the quality checks they conduct.
Can I ask in your witness statement, where do you state that it's a thorough check and that the deglazing occurs during pre-inspection?
This is the practice they do.
Okay, where does it say that, please, Mrs. Garish, in your witness statement?
Can I take time to check?
Of course, please. You explain the deglazing process, but you do not state at any point during your witness statement that the deglazing process occurs thoroughly. You don't give us details of who it is. All of this is completely new information that's arisen during your answer just now.
But that is the practice they do.
You don't state it in your witness statement, do you? Now, you mentioned that they're not able to test the DNA coding.
Deglazing, you can see that in that paragraph. That is a method they also follow in our unit. When they come for inspection in our unit, they follow.
Doesn't say that though, does it, Mrs. Spanish? That's not what your witness statement says. Your witness statement talks about what the deglazing process is, not that it occurs during pre-inspection. Now, you've just mentioned as well that they're not able to test the DNA coding. So that means that during a pre-inspection, if you agree with what I'm about to say,
yes,
ECOLOG would not know what the fish species was inside and would therefore be able to check that it correlates or is the same as the label.
No, they cannot check DNA.
Thank you. Now, Ashman Municipality and Planning Department issued a food certificate, didn't they?
Yes.
Now, what Ashman Municipality and Planning Department isn't able to do, are they, is verify whether the goods inside the packaging is in compliance with the purchase order between the parties or the UN product specifications.
The municipality checking is to check whether the product is export worthy.
Just from Ashman Municipality's perspectives?
Yes.
Yes, thank you. May I ask if we can turn to, for your PDF reference, 1489, and for the trial bundle, it's 05-1175.
Okay.
Okay, so this is the Geoscience Testing Laboratory.
Yes.
Document, and we're just going to look at the cod fillet for simplicity because we know there's a number of different ones for different fish. And
yes,
we can see you're the contact person,
yes,
as down as Ms. Renew, that's correct, isn't it?
Okay.
Okay, thank you. Now, this was a sample received on the 16th of September 2018, isn't it? You can see that date on the document. If you look at sampling date dash time, it says 16/09/2018, which is 16th of September 2018.
Okay.
Yeah. Now, do you agree this was prior to when ECOLOG will have received the cod fillet? Because the testing was done in advance of receipt.
Cod fillet with the production date 10/9/2018.
So this was your sample. This
Yes.
was done before ECOLOG will have received the cod fillet.
Yes.
Yes. So we don't see from this, do we, that it's a confirmation that the sample that was tested was the same as the batch that ECOLOG received on the basis of this document.
Yes.
Can I ask you now, and I apologise, I'm taking you to lots of pages, so I want to apologise in advance. I'm going to take you to more pages if that's okay. If we can go to PDF 377, and for the bundle reference, it's 0563.
Page number
377, and for the bundle reference, it's 05-63.
Okay.
Okay, now this is an email dated the 12th of February 2019, isn't it?
Yes.
And you answer the question, do you have set the temperature of the water? That's the question that's posed to you in the email, and you answer it, don't you?
Yes.
And you say, we conduct deglazing and thawing only in chill water with a temperature range of 0 to 5 degrees Celsius. We have separate chill water line for processing. That's what you state as your answer.
Yes.
And you're saying that we do it.
Yes.
Yes. Doesn't say ECOLOG does it, it says Eastfish does it.
Yes.
Now, that's actually an incorrect method, isn't it?
No, it's not incorrect.
Because what you're doing differs from national and international methods.
But it's not below the standard. It's up the standard of national standard. National standard says room temperature, but we take higher standard, like temperature. Lesser temperature means it is safe for the quality of the frozen product. So for 0 to 5 degree is actually good for the quality of the frozen product. At higher temperature, there is chances of contamination, bacterial contamination. It is a danger zone for the frozen product. So this is not a deviation from the standard, but it's upgrading of a standard. Our in-house standard is upper than the international standard of room temperature.
But as you've just said, Mrs. Girish, actually what you're doing varies from international standard, which says it should be room temperature. You're making an assessment which you don't have expertise on to say that your method is a higher standard, but it does vary from the requirement of room temperature.
But the difference, if we deglaze in 27 degree, it will be deglazed in a short period. When we do in chill water deglazing, we take more time, but the quality of the product and quality of inspection is better.
No basis for saying that it's better, though, do you, Mrs. Girish? And that's actually why the UN raises the issue, as we've seen in the email communication, that actually it wasn't better at all. The deglazing was incorrect and not in compliance.
They may say it's beyond the standard, but it's not a lower standard.
Now, if I can ask you please now to turn to
perishable, it's a perishable good, and the lower temperature is always good for the product, frozen product. And the value will be same if they do in the same way.
As we've addressed, we have an international standard that Eastfish doesn't comply with. But if I can now, to move on from this point, take you to page for your PDF 2416.
And, excuse me, ma'am, one more thing. In this country, as you know, the temperature is so high and the line water is very hot. We provide the chill water line in the processing. So we use chill water every time for the processing.
Which you state in your answer. What differs is the temperature in relation to that water, doesn't it?
Temperature difference. Yes.
I ask you please to turn to page 2416 of the PDF, and for the bundle trial reference, it's 6-566. Let me know when you're there.
Okay. Okay, I am in 2416.
Wonderful, thank you. And this is an email on the 7th of August 2019 from Mr. Gelov of ECOLOG to Eastfish, isn't it?
Yeah, yes.
Yeah. And this is concerning the MINUSCA client. And it says in the second paragraph, ECOLOG's management has negotiated with MINUSCA client that subjected goods to be accepted. The most we could object to was that the goods was not fully rejected. In all demand by ECOLOG to resolve this issue, the product was accepted, but to be charged for differences in glazing variance, as stated on the NCR attached. Now, what we've been talking about has been MINUSMA, and this is in relation to MINUSCA. They're two separate missions. Do you agree that in relation to MINUSCA, it was found that there was a glazing variance?
Actually, this mail is not to me.
It isn't, no. You're not in. You're not in the to list.
Okay.
But
so, what was your question?
If I can ask you, please, to turn to paragraph 16 of your witness statement, because you're addressing this point. So okay. You've seen that email of 2416. If I can now take you to paragraph 16 of the witness statement, which, as you correctly state, you're not included in the to list, but you say,
okay,
you address that that you were ready to rectify any glaze issue by providing additional quantity, which was never demanded by the defendants. Now, you state that it was never demanded by the defendants, but we can see in that email, can't we, that actually in relation to the MINUSCA mission, that there was an attempt by the defendants in order to renegotiate in relation to rectifying your glazing issue.
Actually, we weigh the product first and then do the glazing. So the weight will be what is required by the customer.
So that means that those two figures can never be correct.
The weight will be what they asked for.
So they will differ automatically. In relation to Eastfish, we went at the very beginning, if you recall, to a website snapshot of Eastfish, where it says that it's a global leader of the seafood industry. Would you agree that Eastfish is a global leader?
Yes.
Yeah. Can we please turn now to page 602 of the PDF?
Bundle reference, Ms. Walker.
Oh, apologies, Judge. 05-288.
Thank you.
Sorry, the number is 6.
602.
I'm sorry, Miss Emma. Your Honor, we can't see you because of the background light. It's completely. I'm sorry to bother you, but.
I'm in 602.
Wonderful. I'm just going to wait for the judge to finish closing his blinds before I carry on. Thank you for confirming, Mrs. Girish, where you are. And just to check, you've heard me.
For the botheration, I mean.
That's all right.
We would like to see your expression, so we can't see that, frankly.
So we're all on page 60205-288. We can see here, this is a label for frozen fish red snapper whole, can't we?
Okay.
Yeah, and it says not for resale, for UN consumption only.
Yes.
It says that it's been packed and exported by Eastfish.
Yes.
And it states that the FAO zone is 51, Kochi,
Yes.
India.
Yes.
Yes. Now, can I ask, please, if we can turn to page 370, bearing in mind we've just seen the label of the red snapper. And the bundle reference is 05-56.
Page number? Sorry?
70.
I didn't get you. Sorry.
Apologies. 370.
Oh, okay.
And I'm looking at the second half of the page of 05-56, which is an email.
Sorry, I'm not there. 370.
370. I will pause until you let me know where you are.
Okay. Okay.
Thank you very much. So we can see this is an email from ECOLOG to Eastfish that says the red snapper ordered under various POs was rejected due to fails product origin labelled. The product labelled origin India FAO zone 51 is not correct, since as per attached FAO fishing area 51 reference is not native in that zone. I won't try to say the Latin. In addition, as per different organisations' research, FAO zone 51 has a lot of Latin, but not FAO 31. So do you agree that this was brought to the attention of ECOLOG in this email to say that there are two different zones, and according to ECOLOG, red snapper is not found in 51?
Red snapper is found in 51. You can check with the Google. Red snapper is available in FAO 51. It's available. Red snapper is available.
Actually, according to expert evidence, which I'm going to take you to, an expert believes that's not the case. If I can ask now, please, if you can turn to PDF 2485, and the bundle reference is 6-635.
2485.
2485.
Okay.
Are you at that page?
Yes.
And we can see, according to 2485 or 06-635, this is setting out the geographical distribution, isn't it, of different species. And we can see at the bottom, Lucianus, I'm going to have to try and say it, Lucianus campuchianus, which is the Latin term for, I've got to presume Latin, for red snapper, isn't it? It's the species name.
Okay, all these Lucianus species is together called, the common name is red snapper. That is why I say red snapper is available in FAO 51. Red snapper is the common name. So it is available in FAO 51 also, but Lucianus campicanus is more particular to the species.
we discovered at the very beginning of your evidence, Mrs.
Sorry, ma'am,
Grish.
you asked that whether red snapper is available or not. So I said red snapper is available.
Mrs. Grish, as we mentioned at the very beginning, and as you confirmed at the very beginning of your evidence, you don't have any expertise in fish testing, do you? You don't have any qualifications, and you're not an expert of fish testing, are you?
No, luteolus. What I told you is red snapper. Red snapper is available everywhere, but Luteolus camphicanus means that is a particular species. When you asked whether red snapper is available, I told you yes, it is available in FAO 51.
Can I ask, please?
Sorry,
Apologies, Judge.
What is the document we're looking at on page 06635?
So this is a document that's been exhibited by Mr. Gelov in order to explain from his knowledge that that the geographical distribution of, as he says, Lutanus capuchanus, which is red snapper, is found in zone 31.
What is the document? It's 2 pages out of some document. I'm asking what the document is.
I only know it as being a document that is being used to be relied upon by Mr. Gelov. But what I will now do, if I may, is take Mrs. Girish, please, to the expert report.
Just before we go, Mrs. Girish, do I understand you to be saying, while we have that document there, do I understand you to be saying that all those species of Luteana on that page, they are all commonly known as red snapper?
Yes, all the Luteolus. It is commonly known as, the common name is red snapper. This is the scientific name. Luteolus argentimaculatus, Luteolus camphicanus, these are the scientific names. But Luteolus means red snapper. It is, you can see the zones, 54, 51, like you can see the zones. It is available all over the world.
All right, thank you.
Mrs. Girish, if I may, as we've already addressed, you don't have any expertise in the testing of fish or qualifications in it, and of course you are a factual witness. But if it may assist, I'm going to take you to Mr. Nader's expert report for the bundle reference, the trial bundle reference at 7-4, and I'm going to get the PDF page now for you, Mrs. Grish, if you give me one moment. So from the PDF perspective...
Sorry, ma'am, I am not there.
No, I get the PDF for you to make it easier. I apologize. It's 255.
You don't want me to take 704?
So it's 2554 of the PDF.
2554.
Yes, and it's 07-4 of the trial bundle.
4.
2554.
25.
And I'm going to ask you to look at the second paragraph on 2554, where it starts with a further mislabeling was detected. Have you found that page?
No, sorry.
Okay, no, please take your time.
Yes.
Wonderful, thank you. And we can see at the second paragraph, it states, a further mislabeling was detected by the UN with regard to frozen red snapper ordered by ECOLOG under various PO numbers. Products were labelled with the origin zone FAO zone 51, which cannot be correct, as this fish, red snapper, Lucianus campichanus, doesn't say Lucianus, it says specifically Lucianus campichanus, is not native in that zone. This underlines the severe flaws in the food safety and quality management system of these fish. Mrs.
Can I
Girish,
explain that?
Given that you're not an expert in this case, are you saying that factually you disagree with the wording of this expert's paragraph?
Actually, we import the fish from that FAO zone. we import with the government authorities approved papers. We have the documents. One country approves the documents with their government and sent to us along with the product. It says it is from their FAO zone and the species is Luteanus camphicanus. We have the document approved by the government of the exporting country. So how can I suspect such a thing?
So, Mrs. Garish, what I'm putting to you is that as a non-expert, you're saying you disagree with an expert in relation to this point. That's just it's just that question.
Well, I don't think that's what the witness is saying. I think the witness is saying that so far as she is aware, they had a document from the country from which the fish was exported,
Yes.
certifying that it was Luteana camphicanus, and that's what they relied upon. Is that, have I got that right, Mrs. Girish?
Yes, we have the documents from the government of the exporting country.
But those documents haven't been produced to the court, have they?
Okay, I will talk with my advocate.
Yes, all right. Sorry, sorry, Ms. Walker, I interrupted.
Not at all. My final question, actually, Judge, was the question you've just asked, is that the documents have not been provided in order to set out that distinction. I have no more questions for Mrs. Girish.
Thank you.
That concludes
Mr.
my
Dinesh,
questions. Thank you.
Do you re-examine, Mr. Dinesh?
Yes. I'm asking Ms. Renu Ghosh once again, how many years experience you said?
30 years.
Have you been testing? Have you been deglazing all these years?
Yes. And I'm trained in food safety with a food safety level 5, HACCP level 5, and FZE version 5.1. I am certified.
Good. So, and you have a graduation in fisheries, isn't it?
Fisheries science.
What do you mean by this fisheries science graduation?
That means after the 12th standard, we go to the graduation for 4 years. It is at that time it was under the Agriculture University, and now it is Independent Fisheries University.
Right. So you have this, you have a good knowledge about the marine ecology and products.
Yes.
And have you gained experience in all these 30 years?
Yes.
So you are an expert.
Yes.
Thank you.
Thank you.
Right. Thank you, Mrs. Garish. That completes your evidence. There's no reason why we need to retain Mrs. Garish any longer. She can be excused, Ms. Walker.
Absolutely, from my perspective, Judge.
Yes. Well, thank you, Mrs. Garish. You're free to go about your business.
Thank you.
Mr. Dinesh, would you like to call your next witness?
Yes, I can. Give me a moment, Your Honor. Your Honor, are we examining the defendant's witness today? Will there be?
I don't know. It will depend on how long your witnesses take.
Yeah, my humble request is if the witnesses are done in a day at one go, that would be ideal so that they won't be in a position to reflect on the questions and make it better in the subsequent day. So it happens in trials.
Well, I don't know. I think we should press on, Mr. Dinesh. I think we should use the time. We've only got 2 days for this trial. I don't want to run out of time.
Yeah, absolutely. I try to minimize my arguments time because I'll just give you the argument note also, because it's mostly the matters are on record.
Let's just get on with it. Worry about this later. After we've finished, we'll see how long the next witness takes, and we'll worry about it then.
Yes, true. Thank you.
Hi. Hi, good afternoon.
Good afternoon. Mr.
Hi,
Dinesh.
Mr. Girish, can you adjust your camera a bit so that your whole face can be seen by the Honorable Court?
Apologies,
sir.
Judge. May I ask a very quick question just before we allow for Mr. Balan to give evidence? It's just popped up that the name of the person, the Teams account, was actually Renu Girish, who we've just heard from. Is that meaning that both parties are using the same Teams account and they've simply just now amended the name and that they've actually been in the same room for the entire point of evidence? If Mr. Dinesh is able to assist me in that, because the person that's just been entered into the lobby was Renu Girish, who we've just heard from, and then the name was changed to be Sadir. Could I just ask whether they were both in the same room at the point of giving evidence?
No, they are not in the same room. It's a big office. And I don't know about Renu. So far as Mr. Sudhir is concerned, he's in the same office, but there's a big office, 2-3 multiple flats are there. So we don't know whether he's using the same thing. I didn't notice that. Anyway, he's isolated. Nobody is there and nothing is there.
Thank you for clarification.
Your Honor, may I proceed with
Yes. Yes, please, Charlotte.
Thank you. Hi, sir. Would you please state your full name and occupation for the record? May the witness please state his full name and occupation for the record?
Your Honor,
Mr. Balan, can you hear us?
may I hear? I'll just translate what she said. Mr. Sudhir, you have to tell your name and the occupation of yours to the Honorable Court.
Sudhir Pedikalakandi Balan, Sales Supervisor, East Fish Processing Company.
Thank you. Will you be swearing or affirming today?
Sorry?
Do you have a holy book that you will use to swear to tell the truth?
Yeah.
Okay. May I please see it? Can you please confirm? May I see it? The holy book. If you have it, can I see it, please? Sir, if you will be swearing, can I please see the holy book? Can you put it before the camera so the court can see it?
If you have a holy book, lift it up in front of the computer so that we can see it on the camera.
Sir,
May I-
would you like to affirm?
May I clarify? Your Honor?
Yes.
Yes. Mr. Sudhir,
Yes.
either you have two options. Either you can affirm in the name of God, or you can touch your holy book and say that in the name. So you have two options. You can say that you can affirm, or you believe in a holy book, you can touch the holy book and take an oath.
Holy book.
Your option is yours.
Well, now show us the holy book that you have there.
Okay.
We can only see your face. We can't see the book. Show us the book. Lift it up and put it in front of the camera like that. Lift the book up next to your face.
Okay, sir. I'll take.
Lift. Do you have the holy book there? Yes, there it is. All right.
Okay. Place your right hand on the book, please. Okay, and repeat after me. I swear by the Almighty God
I swear, mighty God,
to say the truth,
to say the truth,
the whole truth,
all truth,
and nothing but the truth.
nothing but the truth.
Thank you.
Mr. Dinesh. Mr. Dinesh, you're on mute.
I was in the commotion of holy book business. Mr. Sudhir.
Yes, sir.
Yes. Can you tell your full name for the records of the Honorable Court?
Sudhir Padikkalakandi Balan.
And what is your designation?
Sales Supervisor.
What is your job as a sales supervisor?
Sales and Marketing Executive.
You have given your witness statement,
yes,
which is 0684 to 0690. Is it correct?
Yeah, correct.
Please say yes. Don't use the word yeah in the court.
Yes.
Please. You have given a second witness statement, that is 06687 and 06690. Is that correct?
Yes.
You have produced exhibits which is at 0691 to 06581. Is that correct?
Yes.
Kindly come to your witness statement, which is at 0690. Are you there?
Yes.
That is dated 10/2/2022, and you have put your signature there. Is that correct?
Yes.
And kindly come to witness statement. I'm sorry, I'm also using the digital copy. You have the number with you?
PDF number?
I'm sorry, I'm not able to. My iPad is playing. 1 second. Can you give the number of witness statement?
0680.
I'm not able to track it. I don't know what happened. Yeah, witness statement. I just want to. This is the first witness statement or second witness statement?
First.
One which. Kindly come to your second witness statement. This is the first witness statement at page this is the first one. Yeah, 02202, which we have mentioned. And where is the second witness statement? Take the second witness statement. Give me the number, please. My apology, my lords, my iPad is acting, so just. Yes, kindly come to your second witness statement, which is dated C332022, and you have, and there is a signature at 06690. Is that your signature?
Yes.
When did you join the claimant company?
2006.
And are you the chief person who was dealing with this transaction?
Yeah. Yes.
Were you dealing with ECOLOG International only or ECOLOG UAE?
Both.
The ECOLOG UAE persons are they coming to your factory?
Yes. Many times.
And any person from ECOLOG International, are they visiting?
Yes. Mr. Vegetain, Mr. Siraj, Stephen.
Whom generally you interact with ECOLOG people? Can you just name them?
Yeah, Vegetain, Florine Sethi, and Stephen, Siraj. Over phone and personally meeting, and it's the office and outside also.
Okay. So you oversee the sales normally
Yes,
and marketing.
yes.
How long you have been dealing with ECOLOG?
ECOLOG almost 5 years.
5 years.
Yeah.
That is up till today or at the time of the dispute?
At the time.
Can you just mention the year?
Yeah, at 2019 till 14 to 2019.
So, was there an issue with ECOLOG at any point of time in your surveys apart from this issue?
There is no, there is no issues.
Yes, there was no dispute with ECOLOG all these years.
No disputes.
Are you supplying goods to UN?
Yes.
Are you supplying even now?
No, not UN. We are giving ECOLOG other companies, not to direct to UN.
Okay, you give the products to companies in between.
Yes.
And they in turn give to UN.
Yeah, this is a local purchase order. We are ready to the product in our factory, in our premises. They come and load, they inspect it and load.
Fine. So you have not been blacklisted by any of these companies?
No.
Have you been blacklisted by ECOLOG?
I don't know.
You don't know?
No.
Fine. Have you got any communication regarding blacklisting?
No.
Do you know that ECOLOG has been blacklisted or not blacklisted? You have an idea about ECOLOG status?
Not blacklisted.
Okay. So you are still supplying to other companies which are in turn supplying goods to UN?
Yes.
There was no complaint at all so far as your supply is concerned so far, apart from this issue.
Because this time also they are asking for new bid now. The 2019 also they are asking for a new bid, no price and yeah.
No, can you just explain what is this new bid you mentioned?
After 5 years they are asking a new bid. They send mail for the new price and the same product.
So even after this dispute arose, according to you, they sought bid from you again?
Yes.
That is it a single mail or was there any series of correspondence between you and
correspondence? Yeah.
They sought it. Then why did you not go forward? Why did you not go forward?
At time the payment is pending. That's why we are not give the new bid.
Right. Fine. Thank you. I'm done.
Thank you. Ms. Walker.
Thank you, Judge. Good morning or good afternoon, as it must nearly be for you, Mr. Sadir. Could I just check that I refer to your surname as Sadir and not Balan?
Sadir, yeah.
It is Sadir. Excellent. Thank you very much. Mr. Sadir, there was a number of leading questions put to you by my learned friend just now. I just like to clarify that all of the information you've just provided isn't included in your witness statement, is it?
Sorry, I can't hear you.
Apologies, I will say it again. There was a number of points put to you by Mr. Dinesh in a form of what I would describe as leading questions. With regards to blacklisting, you don't refer to any detail in your witness statement 1 or 2, about blacklisting or about the fact that you supply to local purchase orders who potentially may be ending with the UN, do you? I think Mr. Dinesh, you're on mute, but
I just mentioned one submission, nothing to do with the merits. I think it would be, with your Honor's permission, it would be better if you can really mention those questions, because number of leading questions is a vague term. So if you can really put the question accurately to the witness, that would be fine. I think the witness would be in an easier situation to answer those questions. I'm just telling you to make your job easier.
Well, look, the proposition, I think, Ms. Walker, is that you should break it down into the individual
Right.
questions. Right.
I don't feel, to make it even easier, Mr. Sadir, you've just answered a number of questions, haven't you?
Okay.
Yes. Is that correct? You agree? You just answered a couple of questions for Mr. Dinesh. Did you answer some questions just now?
Okay.
Yes. Is that, when you say okay, is that a yes or a no?
Their voice is lagging. No, I can't hear you.
Did you answer questions a moment ago from Mr. Dinesh?
Okay.
When you say okay, is that yes or
Yes.
no?
Yes.
I would appreciate if you can say yes or no to the question. Thank you. You've provided some answers a moment ago, didn't you? You provided answers to questions a moment ago.
Sorry.
You answered some questions, didn't you? Mr. Sadir, can you hear me?
I cannot hear you.
Judge, and can you hear me okay? Sorry, Judge, you're on mute. I didn't hear whether you heard me.
Mr. Dinesh, there seems to be a problem. Where is Mr. Sadir? Is he in your offices or is he somewhere else? No, you seem to have frozen, Mr. Dinesh. Mr. Sadir, can you hear me?
Yes, sir.
Right, where are you, Mr. Sadir?
Yeah, I am in another office, sir.
Are you in the same office as Mr. Dinesh or not?
No, it's not in front of me, sir. The other office.
But you're in the same building?
Yes.
All right. Well, we need somebody, perhaps Ms. Walker, perhaps you could try again. If the witness can hear me, it's odd that he can't hear you.
It is odd, yes, sir.
But
Yes, Judge.
The problem is we've lost Mr. Dinesh, so until we get Mr. Dinesh back, there's not much we can do.
Judge, if it's helpful, just to confirm that I can hear both you and Mrs. Walker as well.
Thank you. Right, but we need to get Mr. Dinesh back on the line. Charlotte, perhaps you could telephone Mr. Dinesh's office and try and find out what's going on. Mr. Dinesh, you're back with us.
Yeah, I'm back.
All right. Now, Ms. Walker, perhaps you could try again and see if Mr. Sudhir can hear you now.
Yeah, I'll just, Mr. Sudhir, can you hear us?
Yes, yes.
Yes.
Right.
Whenever
No.
the question is, 1 second, Mr. Emma, I'll try to help you. Mr. Sudhir, whenever a question is put to you, you answer very specifically. Don't say, okay, either yes or no. Understand the question and respond to the question. Don't say, okay, because my learned friend, Mr. Emma, is expecting answers from you.
Yes.
So be clear on that aspect.
Sure. Yes.
All right. Ms. Walker.
Thank you, Judge. Mr. Sudhir, can you hear me?
Yes.
Thank you. If at any point you can't hear me, please do let me know. And if at any point you don't understand my question, please do ask me to repeat it.
Yes.
Now, before we commence, can I ask, are you using a hard copy or a soft copy bundle? Are you using a hard copy or soft copy bundle?
Hard copy.
Hard copy. Okay. So I will refer to trial page references, which I'm sure you've seen because you have got a hard copy bundle. And I will also refer to the PDF page number as well.
Okay.
Okay, thank you.
Yes.
Excellent, thank you. Now, to go back to what I asked before we had some of our technical issues, you answered a number of questions a few moments ago from Mr. Dinesh, didn't you?
Yes.
And the answers that you gave to Mr. Dinesh are not contained in either of your two witness statements, are they?
Yes.
So what you provided to us a moment ago was new information that we did not know prior to today in relation to the relationship with ECOLOG.
We have 5 to 6 years, we are continuous doing the business. We have a good relation with ECOLOG.
Well, if we can go to paragraph 2 of your witness statement, please.
Yes.
You say that Eastfish and ECOLOG have been in business since 2014.
Can you repeat?
Yes, of course. I should grab your witness statement so I've got a hard copy in front of me. You state at paragraph 2 of your witness statement that you have been in business with with ECOLOG since 2014.
Yes.
You mentioned a moment ago about a timeline in relation to when you stopped being in business with ECOLOG, and you said a moment ago that you don't know whether you're still in relationship with them. Okay, I'll take you back to the paragraph 2, if I may. First line, the business relationship with the defendants had commenced in 2014.
Yes.
Now, a moment ago, you gave two different answers to a question put to you by Mr. Dinesh. You firstly stated that you're still in business with ECOLOG, and then you stated that you do not know whether you still have any contracts with ECOLOG. Which of those two answers are correct?
No, this is no contract because this is a LPO, local purchase order. We are arranging all goods against the local purchase order.
Right.
There is
And the
not-
local purchase. Apologies, I interrupted. Please, Mr. Sadir, you carry on.
Sorry, can you repeat?
I interrupted you. Please carry on. Okay, so just to confirm, when you were answering the two questions from Mr. Dinesh, you're actually referring to other companies and local purchase orders, not ECOLOG.
We are doing other companies and Supreme.
So the answer was yes. The answer is yes. You were referring to other companies. You weren't referring to ECOLOG.
No.
Mr. Dinesh, I don't think you can shake your head and answer the question for him.
I just want to know. No, I just want to clarify because I'm so sorry from your part for this thing. I think, of course, I also did not understand the question. Just frame it because he has an issue in understanding English. So, and if you bifurcate, you won't be able to correlate it. So just make it in a sentence or pause it so that he can understand and answer the question.
Mr. Dinesh, the question was very straightforward. He refers to companies. He's not referring to ECOLOG. That's the question, and he answered yes. I don't think, Mr. Dinesh, you're able to shake your head and be able to answer the question for him. But Mr. Sadir, moving forwards, you referred a moment ago to the fact that you wanted to discuss the topic of blacklisting. Now, do you agree that the issue of blacklisting is not referred to in your witness statement? Whether you were or were not blacklisted generally by companies?
No, East Fish not blacklisted.
But what we do know is that you were placed on hold by the UN as a result of this dispute.
UN not blacklisted. We are supplying continuously. No.
But Mr. Sadir, you mentioned a moment ago that you don't directly supply the UN.
Now we are not supplying.
Now, ECOLOG prepared the pre-inspection report, didn't they?
Pre-inspection report we are sending as per the instruction of ECOLOG QA. The loading time there come and inspected all goods before loading.
So you agree, ECOLOG prepared the pre-inspection report?
Our QA is preparing this inspection report as per the instruction of QA of ECOLOG.
Mr. Sadir, it's a yes or no answer. You just seem to repeat the same sentence. Do you agree that ECOLOG prepared the pre-inspection report?
Our QA is preparing this pre-inspection report.
I'll ask the question again. Do you agree that ECOLOG prepared the pre-inspection report? Do you agree? Mr. Sadiq, can you answer that question, please?
The pre-inspection report is preparing our QA as per the instruction of ECOLOG QA.
You've repeated the same sentence now 3 times. Can you just answer the question? It's a yes or no answer. Do you agree, yes or no? Am I saying something incorrectly or am I saying something correctly? Do you agree with me?
Yes.
Yes, okay, thank you. Now, do you agree that the pre-inspection consists of looking at the packaging, the label, the temperature, the weight? These are all examples of what the pre-inspection consists of, isn't it?
Loading report, loading the ECOLOG QA, they are come and inspected.
What they didn't, apologies, I interrupted. Are you pausing in your answer, or would you like to say more?
Yes.
Okay. What ECOLOG didn't do, did they, was they didn't open the packaging in order to test the DNA coding of the fish, did they?
The product we are ready to arrange in our premises. They come and check every product.
Well, they don't check every product, do they? Because what they do is they do a general pre-inspection of all the products as a whole. They don't sample the product for its DNA coding, do they? I'll ask the question again, Mr. Sadir. Does ECOLOG sample the DNA coding of the fish?
Yes.
They do. Okay. Now that directly contradicts from the evidence that actually we've heard earlier on this morning from your colleague, Mrs. Garish, because what she said to us is they don't test the DNA coding.
DNA, the loading time, they are not testing the DNA test.
So you're contradicting yourself. Now they don't test the DNA coding.
No.
They don't. Okay. Right. At paragraph 2 of your witness statement, you reference the microbiological and analysis report.
Yes.
Yeah, can you see that's on? It's on 6-85. It's paragraph 2. You state, and after the load, sending the pre-inspection report with the photographs and microbiological and chemical analysis report. Okay. Now that lab analysis report is from Geoscience Testing Laboratory, isn't it?
These are technical things you can ask our QA team.
Okay, no problem. I understand. Okay, so when you refer to that, you're saying you don't have any knowledge of any detail to do with microbiological and chemical analysis.
Microbiological analysis, we are giving every shipment.
Okay, right. So when in your witness statement, you refer, for example, at 6-88, which is page 5 of your witness statement, and you talk about DNA, you're doing so without any knowledge.
Can you repeat?
Of course, at 6-88, now the paragraph numbers are for some reason incorrect. It's entitled DNA-species, paragraph 2, and it runs from half down 6-88 to half down 6-89.
I don't clear. Can you repeat?
Of course, are you where I am? Are you looking at your witness statement?
I'm sorry, Miss Emma, you just mentioned the numbers properly, 6- and all that, you won't be able to follow it properly. So it's that 6 that give the numbers specifically so that you'll be able to follow.
I
think it's not able to.
I did, Mr. Dinesh. 6-88. or page 5 of your witness statement, if that assists. I'm not 100% sure how your bundle looks, unfortunately,
Yes.
Mrs. Sudhir. You've got it, excellent. So you discuss that at the beginning, the claimant had always supplied products that were compliant with UNSTD and firmly believed that the products allegedly rejected by the UN and disposed of are not the same products supplied by the claims. The defendants has never asked for DNA species test, and you go on to talk about disposal and about the issue of DNA. So are we in agreement then that you don't have any expertise in relation to the DNA coding of fish?
No, I am not admit this DNA test because I'm in a sales person. I want to keep the business now. That is why
Okay, so you agree with me. You don't have any expertise in relation to the DNA of fish.
No.
Yeah, okay, thank you very much. Now, what you do have knowledge of, though, I understand, and correct me if I'm wrong, is that Eastfish prepared the labels for the packages. Is that correct?
Yes, it's fish packing. No, we are do the packing as per this LPO local purchase order.
Yep. Okay. And actually what we've discovered is that the labels were not representative of the contents of the package. That's correct, isn't it?
The labels they provide, label instructions. They follow their instructions only.
So they follow instructions only. They do not follow actually what's the necessary contents of the package.
Yeah, they have to give all details, the label details.
So what happens is ECOLOG tells you what to say on the label, and you just make sure that label is correct on the outside of the product. It's not about the actual contents being reflected inside the package.
No, inside the package, the same product, no.
But as you mentioned before, you simply are just doing an exercise of replicating the label.
Label format is providing ECOLOG.
It's provided by ECOLOG, and you copy that. Now, can I ask, please, if you can turn to, now it's PDF 234, or for bundle reference, it's 1-215.
Which one?
It is 1-215 or PDF 234. And while Mrs. Sudhir, you're searching for that, Judge, I'm very conscious of the fact that your time is, or UAE time is now after 1 o'clock and after lunch. I'm happy to stop at any convenient time for you.
Is this a convenient time
It
now?
may actually be, because the page reference has been given, and I'll be taking Mrs. Sudhir to that page. I'm more than happy to pause now.
All right. Well, Mr. Sudhir, Mr. Dinesh, you would want time to get some lunch. Would 45 minutes be enough time for you to get lunch, or would you like an hour?
45 is good enough. 45
Mr. Sudhir, can you can get some lunch in 45 minutes?
Sure.
Yes. All right. Well, we'll resume on the hour, just a little 2 minutes after, just 2 minutes after the hour, whatever the hour is, wherever you are, and we'll resume then. Now, Mr. Sudhir, in the meantime, you shouldn't speak to anybody about your evidence. So don't talk to Mr. Dinesh or any of Mr. Dinesh's staff about your evidence. You just keep yourself to yourself before coming back here on the hour. All right?
You can't go anywhere. You have to be confined to your room. You can't speak to any person or any.
He could get some lunch.
Supply.
He could go out and get some lunch if he wants, Mr. Dinesh. But he just don't speak to anybody.
I just want to dispel that impression. I mean, I just want to, because the integrity of the court is important and the case.
Right. Okay. We'll resume a little after the hour. Thank you.
Thank you.
Thank you.
Mr. Dinesh, are you there? Yes. All right. Good. All right. Thank you. We're all reassembled. Ms. Walker, back to you.
Thank you ever so much, Judge. Mr. Deere, two very quick preliminary points before we carry on with the page that I'm taking you to. During the break we've just had, you kept your screen on, didn't you?
Sorry?
Your camera. During the break, you kept your camera on, didn't you?
Yes, I touched the camera once by mistake.
You kept the camera on or you kept it off?
One time by mistake I off.
Okay.
Then again.
And when your camera was on, you took a mobile phone call, didn't you?
No, it was only 2 minutes.
During that phone call, which I saw because I was sitting in front of my screen, you didn't talk about this case, though, did you?
No.
You also had a conversation with a number of individuals in the room. Can I ask whether that concerned this case or not?
Sorry?
During the break, you were also unmuted and you had a conversation with another individual.
No.
You were, because I heard it. Can I ask?
Only they are bringing the food, no?
Your conversation lasted about 3 minutes and you were speaking not in English. Can I ask if you were talking about anything to do with this case?
Bring my food, only that, no.
Okay, but you didn't, I don't want to sound a very peculiar person, but you didn't actually eat during the time you were there. Your screen has been in front of me the entire time. You weren't eating. So did someone bring food to you?
No, that is by mistake, no.
Okay, so the person that came in didn't in fact bring food to you. Did you speak to them about this case?
No.
So when you said that there was a person that brought food to you, that wasn't true.
Sorry? You asking a
When
question?
you said that somebody brought food to you, that's not true.
No, your voice is lagging. I can't hear you.
Judge, can I check that you can hear me?
Email?
I can certainly hear you, Ms. Walker.
Thank you
Mr.
very
Sudhir,
much.
can you hear Ms. Walker?
I can also hear properly.
Yes. Well, Mr. Sudhir, can you hear Ms. Walker?
Yeah.
All right.
Yes.
Try again, Ms. Walker.
Thank you ever so much, Judge. Mrs. Sudhir, when you said that someone had come in to talk to you about bringing lunch and they brought you lunch, that's not true, is it?
Nobody's come and discuss. No, come and talk. No, here only they bring the food on.
But you just said that someone didn't bring you food. Mr. Sudhir, these are very simple questions. I just want to ascertain whether you've spoken to somebody about this case whilst you were under oath. I was sat at my screen and therefore both heard and saw you having a conversation. There were two.
No.
And I want to understand whether, as you've just said, that you were incorrect that someone brought you food, whether that's the case or not.
No.
No means what?
No, I didn't discuss in matter of this case. No.
And did someone bring you food?
Yeah.
Okay. And is the food on your table?
Finish.
Mr. Sudhir, I've sat in front of the screen. You didn't actually eat food any of the time that you've been in front of your camera.
No, only a little. No. I'm not.
I'm going to move on So I don't want to spend too much time cross-examining Mr. Sadir on his food, but I am a little bit concerned that he's not able to answer the question with any ease as to whether he's eaten food or not. Now turning please to page 234 of the PDF bundle and reference 1-215. Mr. Sadir, I asked you to go to it before the lunch break and I'd like to ask you to look at it now, please. And if you can let me know if it's in front of you or not.
Page
Sorry,
number?
could I just have that bundle reference again, please?
Of course, Judge. It's 1-215.
Thank you.
And PDF 234.
234.
And if you can let me know, please, Mr. Steer, when you have it in front of you.
Yes.
Thank you very much. Now, this is an email dated the 14th of February 2019, isn't it?
Okay. Yes.
Thank you. And this is from ECOLOG to Eastfish, and you are included in the email addresses that this was sent to, weren't you?
No, this is already clear in our QA. The send mail to clear all things.
I'm sorry, what was that answer?
No, this is already cleared by mail. No, our QA team send mail to clear everything. Detailed mail they sent it to ECOLOG.
You're not answering my question, Mr. Sudin. Are you in that, on that email, have you received it? Did you receive it? Are you in the email? It says, hello, George and Sadir. And we can see an email address of sadir@eastfish-uae.ae. Did this email get sent to you?
Yes.
Yes. Now, if we look at this email, which was sent to you on the 14th of February, it states that there were two different labels for the same lot of item 186 shipped in UN missions. One is the lot that we've purchased from you and shipped in Mali, and the other one is what we received from the UN from another UN mission, which is stated as packed by you. As you will see, there are contradictory information when you are packer and exporter, and different when you are packer with different exporter. Please make sure you provide all the details because, as informed, this is an issue with UNHQ, and they have different sample from different items that are packed by you to confirm glazing and also DNA species of the fish. Now, the label, Mr. Sadir, stated that Eastfish was the packer, didn't it?
Yes, we are the packer. This is a clearly reply, our QA. This is a technical things.
So what you're saying then is, in your two witness statements where you address this issue in quite significant detail, that actually now you don't feel that you're able to answer any questions with regards to the labelling, because you say it's a QA issue.
Yeah, the label and everything, the part of our QA team.
Okay, can I ask then, Mr. Sadir, why you, in two different witness statements, and I can take you for every paragraph if you would like, that you detail your knowledge on labelling, that actually you don't have any knowledge on labelling if you're not able to answer this question?
The label, as per the instruction, QA team, this ECOLOG team, ECOLOG QA team. They give the instruction.
Well, you've just said, Mr. Sadir.
Send the label to when we prepare our QA team is prepare the label. Send for the confirmation for ECOLOG QA. After that, we are going to pack the whole product.
Mrs. Sadir, when I asked before the break if Eastfish were the party that labelled, you said yes. Are you now saying that Eastfish does not label? and therefore when the label says East Fish, that's wrong.
No, this is not wrong. We are not wrongly put the label. The label and everything they come and check in before loading.
But Mrs. Sadiq, you're directly contradicting your own evidence, and actually the evidence of your own of East Fish, which is that East Fish does the labeling.
East Fish is labeling, but the instruction of ECOLOG, they come and check now. Their QA come and check this loading time.
Mr. Sadiq, we're not talking about the pre-inspection phase. We're talking about what's in this email, which is saying that East Fish have put on labels which are incorrect. They are labels by East Fish, not ECOLOG. Now, I need to ask the question again. Are you now telling me that actually East Fish never did the labels at all?
The approval from ECOLOG QA, we send the labels and approve from ECOLOG QA. After that, we are putting the label.
Okay, well that directly contradicts your. Yes. It directly contradicts the claimant's case, so I'm a little bit confused as to why that's come about. Okay, well then let's move on with that point. So what you're now saying is that ECOLOG, which we know from Mrs. Garish isn't the case, provides all the labels, and you simply just stick them on. Is that what happens?
Not happen. No, not wrong label.
Not wrong. I'm not wrong. Are you saying that I'm correct in that?
The label is correct. Correct labeling.
That wasn't what I asked, Mrs. Sadiq. I'm asking who put the labels on.
Sorry?
The simple question, Mrs. Sadiq, who puts the labels on the packaging? Okay, to make it easier, how about we get a label up? Let's look at a label. Bear with me one moment and we are going to get a label, because you seem to be giving me multiple answers which all contradict with one another. So let's look at a label. How about we look at page 602 of the PDF and bundle reference 05-288, please.
60?
602 of the PDF, but the bundle reference is 05-288.
Can you repeat
05-288. Let me know when you've got it. This is the frozen fish red snapper whole, is what this is. And we've got a label which doesn't say ECOLOG on it. It says East Fish.
So page PDF number?
The PDF number is 602.
Okay.
Can you let me know when you've got the photograph?
Yeah.
Yes, excellent. Okay, so we can see this is a label, and what the label states is that this label is reflecting that this product has been packed and exported by East Fish. It doesn't say that it's been packed and exported by ECOLOG. It doesn't make any reference to ECOLOG, does it?
This is packed by East Fish, right?
Yes. Okay, so it's packed and exported by East Fish. Who sticks this label on the product?
Producer.
Who's the producer?
The National Seafood Company in India.
Okay, so that means that you are not actually packing and exporting this, are you? You're repacking it, because what you're saying is it's already been packed by somebody else whose name is not on the label, but they stick the label on. So why does it say packed and exported by Eastfish if that's not actually the case?
This is yeah, our product is from outside. We packed in our factory for the instruction of ECOLOG.
So, Mr. Sadiq, that sentence didn't make any sense. Could you repeat that sentence for me?
Sorry?
Could you repeat that sentence? I didn't. You then made reference to ECOLOG, which didn't make any sense. Could you repeat that sentence for me?
This is the ECOLOG is no. This is product from outside. We are packing and exported. Exported means we are giving to the here as per the LPO.
I'm still not understanding that answer at all.
We are packed as per ECOLOG instructions. The producer is National Seafood Company, right?
Okay, right. Let's take this in small doses then. So the producer that you make reference to, what you're now saying is that they stick the label on and they send it to you, but they've already packaged. Because if we think about how you package something, the label is the last thing to go on. It would go on top of the packaging. So actually what you're saying is the packaging is already done by someone else. They've stuck the label on, and all you really are is just a holding process that you never actually do look into what's on the packaging, because you just simply transport what's already been produced by your producer.
Yeah, producer give to not this ECOLOG to our company. They are going to they are doing this packing for ECOLOG. So
you never actually pack these products or label them?
No, this is we are packing and labeling.
So you're a repacker and a relabeler.
Yeah, the producer is National Seafood Company. We are the packer.
But you said a moment ago that the seafood company packs them and labels them. So that means that you then, if you have any role to play, you're doing the same thing again by repacking and relabeling. Or is it the case that actually you don't do anything with these products at all?
Yeah, ECOLOG instruction, we are packing their label.
What I'm trying to ascertain, Mr. Steve, which is actually quite an important thing that's arisen now, is that yes. Apologies, Mr. Mark. Sorry, Judge.
This witness's proficiency in English is obviously quite poor.
Yes, which I've got to say is unusual, given the witness statements are written in very clear English.
Well, I understand that, and that no doubt that'll be a matter of submission in due course.
Indeed.
But I think if we're going to get any sensible transcript of this witness's evidence, the questions need to be kept quite short and quite simple.
Yes, of course.
Yes. All right.
Okay. Thank you, Judge. Okay. Mr. Sadir, you have just mentioned that you get instructions from ECOLOG.
Yes.
Yes. And you said we followed the instructions of ECOLOG.
Yes.
Now, ECOLOG's instruction, as you mentioned, is that they ask you to pack.
Yes.
You've just mentioned that your producer packs.
This is the instruction they give by mail or mail, phone, and we are the personal meeting the time. They know the producer and packing everything.
That's not what was agreed between the parties. What's agreed between the parties, and you state in your witness statement that you are aware of a contract between the parties. And I can take you to the purchase order if that will help you. But it states that you are the packer. So what I'm now trying to understand is, are you the packer or not? Or is the producer the packer?
We are the
I know what our instructions are, but what I want to know is factually what happened. If you can explain it to me. Mr. Sadira, can I ask, are you reading something? Are you read, because I'm not taking you to a document right now.
We are the packer, no? We are the packer.
Well, let me. I'm having terrible trouble understanding your evidence, Mr. Sadir. Let me ask some questions.
So,
The red snapper that we saw in the photograph, that comes to your factory from National Seafood Company, is that right?
Yes.
And in what is the snapper frozen when it comes to you?
Yeah, frozen, come to our factory, then.
And is it wrapped in plastic when it comes to you?
The plastic, all plastic we will do. Without a plastic.
I didn't understand that. I didn't understand that. Can you repeat that answer?
Sir, we have to pack this with the label.
I'm just asking you, how is that? Just listen.
Sir.
How is the snapper? The snapper is frozen.
Yes.
How is it when it comes to you? Is it wrapped by the National Seafood Company?
Yes.
Yes, all right. So it's wrapped in plastic?
The plastic, we will change the plastic, everything.
When it comes from the seafood company, is it wrapped in plastic?
No, they need an individual packing. Then we will do the IWP packing, individual packing. All
just listen. I'm not asking what you do at this stage. All I'm asking is what the National Seafood Company do. So when it comes to you,
sir,
how is it? Is it wrapped in plastic, and is it one fish or is it a lot of fish together?
All together.
All together.
Yeah.
So how many fish are in a pack that comes to you from the National Seafood Company?
This is a different weight, sir.
I'm sorry, I didn't hear that.
The different weight, variable weight per all cartons.
All right. So there'll be different weights of multiple numbers of fish, and then when the fish arrives, is it labelled?
Yes.
And what's the label on the National Seafood Company put on it? What does that?
They give the all documents now, everything, and then this come to our factory. Individual, we packed all fishes.
Well, I'm coming to that. When it comes to your factory, what label are on the packages that have got the fish in?
So we directly import, sir.
Now, what labels are on the packages when they arrive at your factory?
Our QA team inspected and bring this fish.
Mr.
Sadir, can I ask the same question in understandable way? Same question. The same question Your Honor is asking.
All right, we'll have a try.
Because Mr. Sudhir,
yes, sir.
The Honorable Court is asking, when this red snapper is coming to your factory, is it packed by the whatever Eastern food company?
No, that's not the question I'm asking, Mr.
Is there any label? I'm sorry, is there any label?
That is not the question I'm asking, so just leave it to me.
I'm sorry.
All right. Mr. Sudhir, what I'm asking about is when the fish comes to you from the National Seafood Company,
Sir.
It must have a label on it so that you know what it is, mustn't it?
Yes.
So what is the label that is on it when it arrives at your factory?
Label to know our company name.
It has the East Fish name on it
East-
when it comes
East
to your...
Fish. Yes, yes.
And is that the same as the label that we've seen in the photographs?
Yes.
Okay, so that label is put on by the National Seafood Company before the fish come to your factory. Is that
Yes,
right?
yes. Yeah, right.
All right. And when it comes to your factory, what happens to the fish then?
I want to verify, sir. So at that time, when I get the order, we from ECOLOG, we give to.
No, I'm not talking about ECOLOG at the moment. Just deal with what, when the fish comes in, what happens when it comes to the factory? Physically, what happens to it?
No, we keep in our store, and this will this individually packing.
So am I to understand from that you take the fish, that the fish that come in a big bundle, you take out and put in each individual fish is separately wrapped. Is that right?
Yes, yes.
Well, and what happens to the label that was on the package when it comes from the National Seafood Company? Does that stay on the fish? Does that stay on the package that's applied to the fish?
The quality we have to check, no, all.
I didn't understand that. Can you repeat that?
No, our quality is checking every time this fish.
Now, what happens to the label? You said that the label was already on, but then you say you put it into smaller parcels. What happens to does the label stay on, or is a new label put on, or what happens?
The same date and the same label.
The same label.
Yeah.
All right. All right. Well, I don't know if that helps, Ms. Walker, but I'll hand back to you now. I think I understand.
Thank you, Joe. To move away from the topic of label in one moment, there's just one clarification.
Sorry, Mr. Walker, this is not a death case. You're not going to be hanged, Mr. Sudhir. You have to understand the answer and properly answer to the queries of the council, whatever it is. Whatever you understood, you give it. It's not a death case. You're not going to be hanged. Give the answer properly.
Okay, sure.
I wasn't in any way suggesting that Mr. Sudhir shouldn't answer his question properly. Mrs. Sudhir, so we now understand that the label is put on by National Seafood Company, and it's the same label that you use, which we've seen. You've seen that photograph. So would you agree with me if I was to say that East Fish is the repacker? They're not the packer of this produce.
Yeah, some item we are producing. The king mackerel we are producing. We are the producer. Other items we are the packer.
But you didn't pack them initially, though, did you? You're repacking them at your factory. They've already been packed once, and they're being packed a second time.
Yes.
Yes. Okay. Thank you. Right. We're going to move away from the labelling. I hope everyone will be pleased to see that. I'm going to ask you to turn, please, to PDF 813 or bundle reference 05-499.
81.
05-499.
PDF number?
It's 813. Let me know when you're there. the same time as you, so if you bear with me as well.
Yes, 8113.
813. 813. So yeah, excellent. Can you see at the bottom of 05499, this is an email dated the 20th of August 2014 to you, isn't it?
Which are dated?
It's dated the 20th of August 2014 and it is addressed to you.
Okay.
Yeah, do you agree?
Sorry.
Do you agree? Do you agree with what that email says? That it is dated the 20th of August 2014 to you.
Okay, I see the mail. Okay, then what is it?
Yes. Okay, so the question is, do you agree that the date of the email is the 20th of August 2014? The bottom of 05-499 has an email that says from Gary Leo Garrido, sent Wednesday the August of 20th 2014 at 4:04 p.m. to Sadir at Eastfish. Do you agree with that? Mr. Sadir, do you have the page in front of you? Because it's going to be helpful if you do, so you can answer the question.
Agree means what do you mean? I cannot understand.
What can I ask? What's in front of you right now? What page have you got in front of you?
Yes, 5499 page. Okay.
Okay, excellent. We're on the same page. Can you see that at the bottom of this page, there is an email from Garrido Garilio, I'm presuming Gary Leo Garrido, dated, again, for the 4th time, August the 20th, 2014. Do you agree with that?
Yes.
Yes, excellent. And can you see that it's addressed to you? Sadir at eastfish-uae.ae.
Yes.
Yes. And it goes on to the second paragraph. It says, we, ECOLOG International, have been awarded a contract to supply food in 3 UN missions, MINUSMA, MINUSCA and MINUSTA.
Yes.
Yeah, okay, excellent. Now, if we click forwards by 2 pages and we go to 05-501, which is H15 of the PDF.
51.
05501, yeah. We can see the first page of the UN specifications, can't we? So I want you to just move 2 pages from where we just were. We've got this email dated the 20th of August 2014, and then we skip 2 pages and we've got the UN ration standard UN product specifications, which starts 05-501. I've only moved 2 pages, Mr. Sadir, I assure you.
Yes, yes, yeah, UN, yeah.
Yeah, you're there? Excellent. So in 2014, you received a copy of the UN standard product specifications, didn't you?
Okay.
Okay, is that a yes?
Yes.
Yes. So you agree that as far back as 2014, you knew what the UN standards were that you had to comply with.
Yes, we followed the UN standard every time.
Yes. So actually, in conflict with the case that the Eastfish has put forward, you've always known what the standards were and you've always known you had to comply with them.
Sorry.
You've always known what the UN standard specifications were since 2014, and you've always known since 2014 that you had to comply with them.
Yeah, we are following this UN standard, no?
Okay, so you know that they are there to be complied with. Can I ask now, please, if you can turn to page 1442 of the PDF or 05-1128 for the trial bundle.
PDF 1.
1442. Let me know when you're there.
422.
1442.
Yes.
Excellent, thank you. And you can see that this is a Eurofins report, can't you?
Yes.
Yeah, and you can see that it's a Eurofins report that was sent to Eastfish.
This page PDF 1422, right?
Of the PDF, yes, and 05-1128 of the bundle.
Zero 0511
05-1128.
1128.
This is a Eurofins report in draft sent to Eastfish. You let me know when you're there.
PDF number.
Of course, yes, of course, it is PDF 1442.
Yes.
Have you got that?
Sorry.
Do you have that in front of you?
Yeah. This is 051128.
Yes, it is 05-1128. Yes, bundle PDF 1442. Now, going back to my questions, this is a lab report from Eurofins, isn't it?
Yeah.
Yeah, and it is addressed to Eastfish, isn't it?
Yes.
Yeah, and we can see on this report, this specifically was in relation to the frozen cod alert. Is that correct?
Yes.
Yeah, and we can see it was received on the 3rd of December 2018, and I presume that received means the sample was received. Can you see that line?
Yes.
Yeah, and can you see that it says that the sampling was not sampled by Eurofins? This is all in the analytical report box.
But the report is Eurofin, right?
This is from Eurofins. Yeah, this is Eastfish's Eurofins report.
Yeah.
Yeah. Okay. Excellent. And we can see there is a what I would describe as a watermark, and I apologise if that's not a word that you would use, but you can see in grey letters in the background, it's capital letters draft, can't you?
I am not well aware of this. Not that this is a technical. I am in the sales. I'm not well aware. This is a lab analyzed report, right?
But Mr. Siddy, you can read the word draft, can't you? You can see those letters. I'm not a scientist either, but I can read the word draft, D-R-A-F-T. Can you read those letters?
Yeah, which letter?
D-R-A-F-T, draft, has capital letters in the middle of the page. Can you read those?
Draft, yeah, okay.
Yes, yeah. I'm not asking you to give me a technical understanding of that word. I'm just asking you to confirm that you can see those words. Can you, sorry, see those letters? Can you see that word draft? I'm presuming the answer is yes, you can see the word draft.
I see the draft, okay.
Okay, thank you. And we can also see that the sample was analysed on the 22nd of December 2018.
Yes.
Yes, thank you. Now this was analysed pre or post ECOLOG receiving the cod. Did this happen before or after?
But ECOLOG never asking for the testing for this DNA test, no?
No, this is you asking for it. This is EastFish asking for it, not ECOLOG.
No, this is our purpose. We take this report.
Okay, right. We'll take it one step at a time then. So analysed on the 22nd of December 2018. We're agreed on that.
Yeah.
Yeah. Okay, great. Can I now ask you please to turn to page 1501 of the PDF or the bundle reference 05-1187.
PDF number?
PDF 1501. Bundle trial reference 05-1187. Now, we need to remember that this report is about the cod. So if we now go to 1501 of the PDF, we have an email communication of December the 6th, 2018.
PDF number 15?
PDF number 1501. Trial bundle reference 05-1187.
Reference number 05-1187?
Yes, that's it.
Okay.
Okay. Now, if we go, we can see the email is dated December the 6th, can't we? I'm sorry it's upside down. Unfortunately, I didn't create this bundle, so I apologise that you've got to tilt your head slightly. And I'm going to ask if you can now turn the page over to 1502 of the PDF, which is 05-1188 of the
yes.
trial bundle. And we can see at the very first line, loading date is the 19th of December 2018, at the very, very top in bold.
Okay.
Okay, now we've just seen on the draft report that it was sampled on the 22nd of December 2018. Now that's 3 days after the loading date. So we can actually see that what was tested was after the item had been loaded to ECOLOG. Because do you agree there's two different dates, 19th and 22nd?
But we keep the samples, no, all samples in our warehouse. Same load and other, yeah.
So you load it and then you keep a sample. Is that what you're saying?
Yeah, we keep the product, no, for samples. But at the same time, they are not asking for the test.
But there's nowhere on the report we've just seen that says that the sample is actually the same batch of fish that ECOLOG received. We just know it was there is nowhere on the report we've just looked at that says the sample was the same as that received by ECOLOG.
Can you repeat?
Okay. On the report we looked at, it does not say that the sample that was tested was the same as the fish that ECOLOG received. All we know is that it was cod fillet. So this report could be from any cod fillet.
The samples, no, we tested, no, the same product, no.
How do you know that, Mr. Sadir?
No, we keep now all samples in every loading. We keep in our store.
How do you know that, Mr. Sadir?
We know we have a record.
How do you, as an individual, know that?
No, our QA team is now well aware of this. No, they are doing every time the loading product. We keep the samples in our store also.
So you don't know that. You're just trying to rely on evidence that the quality team has told you would be the case, not that you personally know this to be the fact. When you say we, who is we? Because I'm asking about you. Mr. Sadir, you don't know the answer to the question, do you?
No, we submit all details, and I am not in I'm in a sales.
I'm sorry, what was that? You're what?
I am salesperson. No, I am the sales and marketing.
I understand your sales and marketing, but what I'm saying is that you're not able to tell us that actually it is the same sample from the fish that ECOLOG received. You can't say that with confirmation.
I know our qualities, they are checking properly and they are doing very correct way. I am the sales side. The technical, I am not well aware. They are doing.
It's a yes or no answer, Mr. Do you know, yes or no, about the sampling process and how sampling happens? Do you know? Not the quality team. You personally, do you know?
Our company procedure is that all product is the loading after we are keeping this all samples keep.
So you only understand it from what you believe procedure to be. Can I ask now you to turn to page 1484 of the PDF, and for the trial bundle reference, it's 05-1170.
PDF number?
1484. And the trial bundle reference 05-1170.
Okay.
You let me know when you're there. Yeah, excellent. Now what we see here is a further version of the report we've just looked at, which is the date that I referred to before as the analysed date of the 22nd of December, which, as I mentioned, is after the fish was loaded. Now, looking at this document, we can see again that it went to Eastfish, can't we? We can see it went to Eastfish, can't we, on this document?
I needed to verify this. No, this is also the technical.
Okay, so again, when you talk about DNA reports in your witness statement, you're not comfortable actually answering any questions in oral evidence on this point. Is that what you're saying?
Sorry?
Are you saying that you are unable to answer any questions about this report?
Technical specification, I am not well aware. No, I am looking the sales. So the QA team is they are looking all this detail of this.
Okay, well, I'm going to ask you to do something then that's not requiring any technical knowledge. Okay, I understand now that that you're not able to speak to anything to do with the technical side, as you put it.
Yes.
Okay, understood. Can I ask, do you see on this page whether there is the words production date? Can you see the words production date?
Production date also that's all technical. This is all QA. I am take the order to and forward to this production team.
Can you see the words though, production date? I just want you to read the words. Can you see them on that page?
Sorry?
Can you see the words on that page, production date?
Production
date?
date?
To look for the words. Yeah, can you see the words production date on that page?
Yeah, production date, I know.
Where does it say production date?
Production date is on the label and our documents.
No, I'm not asking for it on the label of the documents. I'm asking if it appears on this document in front of you.
Which document?
The document that you've got in front of you, 051170, does it appear on this document? The words production date.
Production date, okay.
No, does it say it? Just asking that question. Are the words production date on that report? The answer is they're not on there, actually, Mr. Sudhir. That the words don't exist because it doesn't actually provide what the production date is for that report. Can I ask if you can go to your witness statement at page 5? I've already taken you to this paragraph. I'm going to take you to it again, which is 6-88 of the trial bundle, and it's page 5 of your witness statement underneath the heading DNA-species.
PDF page number?
Of course. So it's trial bundle 6-88.
PDF number?
I unfortunately don't have that PDF in front of me because I'm using a hard copy. So if you bear with me one moment, I will get the PDF for you. Right, let's get the PDF number for you. It is PDF 1938. And you can see DNA-species at paragraph 2.
Okay.
Okay, and you start this sentence by saying the claimant had always supplied products that were compliant with UN and UNSTD. Yeah, do you agree with that sentence? The start of that sentence?
Can you repeat?
You see, that's what you wrote.
Sorry.
You said the claimant had always supplied products that were compliant with UNSTD. Do you agree you said that? Is that what the word of your you wrote this witness statement, Mr. Dale?
Yes.
I'm going to put to you about whether you wrote this witness statement, but the wording in front of me says the claimant had always supplied products that were compliant with UNSTD. Do you agree that that's what it says?
I am not agree.
Okay, well, so that means that you disagree. You believe that the claimant didn't always supply products that were compliant with UNSTD.
Yeah, we always give the complaint products because I am the salesperson, no?
Mr. Sadi, you just give me two different answers to the same question. I'm sorry to be asking you multiple times, but it's very important that we get answers to questions. And if there are different answers, then I need to understand which one you then want to stand by.
This page number 50688.
Okay. So of the PDF, it is 1938, and of the trial bundle, it's 0688. And it says under the topic DNA-species, you wrote, well, actually, Mr. Sadi, let me ask you this question. Did you write this witness statement? Now seems like a convenient time to ask. Did you write your first and second witness statement?
Yes.
Okay. When did you write this witness statement?
No, we know we are giving the UN standard product, no?
No, Mr. C, that's not what I'm asking. I'm asking, did you write your witness statement?
Yes.
When did you write your witness statement?
No.
I'll ask the question again, Mr. Sadiq. When did you write your witness statement?
This is 10th February 2022.
And you are saying that when I have quoted to you the line, the claimant had always supplied products that were compliant with the UNSTD, that you disagree with that sentence, which is what you first said. Then you said you agree with it. And Mr. Sadir, I'm going to put to you that actually you didn't write either of these witness statements. And that's why you're unable to answer the questions that I'm putting to you that link back to the statements that you've signed, but also you've signed with a statement of truth. You didn't write these witness statements, did you?
As for my instruction, my legal department is preparing this statement, no?
So you didn't write this witness statement.
As per my knowledge, no, my instruction.
So when I asked the question,
Support of our QA team, yeah.
So before when I asked the question, and you said you did, it turns out you didn't. It was written by your legal team.
Sorry again.
I asked you the question, did you write your witness statement? And you said yes. You've just said that it was written by your legal team. And you've just said that it was also done with the QA team.
No, QA team with the reference. No, I don't know the technical things. That is why I want to support our QA. That is why now our QA is doing I am the sales. No,
Can I ask you to
everything. Then this is the technical side is looking our QA team.
On the same page, Mr. Sadir, further up the page, we can see that it says on the very first paragraph of the same page, and I'm looking at your witness statement, and as you've said, you didn't actually write this, it was written by your legal team. And you've just said that when it came to the technical element, you don't deal with it. You say, subsequent to the analytical report dated the 7th of March 2019 from Eurofins, the defendants had requested for the same products, which is clear and evident that the products supplied by the claimant were compliant, I believe that's a typo, with the UNSTD. So what you're saying is that the technical element you don't have any knowledge of. So when you say statements that are very adamant and clear, that it is clear and evident that the products supplied were compliant, that you're not able to say that because you simply don't know.
No, this is technical side, our QA support, no?
So why did you put that in your witness statement? I think what we are discovering is you didn't write your witness statements, Mr. Sadir. You didn't write the first one, you didn't write the second one. No, and that's why you're unable to answer the questions I'm putting to you.
No, as per my instruction, this is our legal department is preparing this. So
you agree? It's a yes or no answer. You didn't write your witness statements, did you?
No, our legal department is preparing this one.
Moving away from the technicalities that you clearly can't talk about because you don't know anything about it.
No, I want the help from our QA team. No, they know the technical side.
Okay, so when you talk about it in your witness statements, you don't have any knowledge of it.
Yeah, I know this.
Okay, well, can I ask then if we go to another paragraph and we can try and understand what you do know. Can I ask, please, if you can turn to page 6-6888 of the trial bundle? And I will get the page reference for you. You bear with me one moment. I'm going to go to your second witness statement. This is a reply to the defendant's witness statement, a very well written witness statement. It's 2538 of the PDF. And I'd like you to look at paragraph 5, please.
PDF number?
PDF 2538.
2538.
And paragraph 5. Let me know when you're there.
2538. Okay.
Yeah, are you on it? So it's 6-688 and it's paragraph 5.
Yes, yes.
Can I ask you please to read paragraph 5 for me?
Sorry.
Could you please read paragraph 5?
As per paragraph 17 of the witness statement is stated that this product's origin labeled as India FAO zone 51 was incorrect because the FAO zone describes red snapper Lithianus campicus as not inactive in that zone. It is to be noted that the claimant has had purchased the product from India, and as per the certificate, the product Lithianus campicus is FOA 51, and moreover, the claimant had already provided the supplier details and supporting documents to the defendant.
Thank you, Mr. Sadir. Now, you are addressing in that paragraph some technical information about the difference of zones. And you are also referring to supporting documents. Now, how are you able to talk about the FAO zone if this isn't something that is within your technical knowledge and ability?
Yeah, I know. This is I discussed with our QA team. I know.
So this is your knowledge.
Yeah, this is, and then I see this documents there. Okay.
And you don't attach. Oh, apologies, I interrupted.
No, so this is we verified the documents.
Well, you don't actually attach those documents to your witness statement, do you? You just say that they had the claimant had already provided the supplier details and supporting docs, but there's no reference at all to what those documents are. It doesn't attach those documents. And actually what you're doing is you're telling something that you've been told to say by somebody else.
No, we submit all documents. You know, there's this FAO zone 51. The documents they mentioned this zone. We trust that document.
I'm sorry, where did you? Can I ask where you stopped mid question, mid answer?
You know, we trust the documents. Now they provide. This is FAO zone 51.
Okay. Do you have knowledge of what FAO zone 51 is and what FAO zone 31 is? Do you have technical knowledge of this?
No, I checked with our QA team. I discussed.
Right, that's all I needed to know. You checked with your QA team, so it's not your knowledge. Right, moving on, please, if I may. We go to page 233 of the PDF, and can we go to 1-214? I know that it's PDF 233. This is an email from ECOLOG on the 8th of March 2019. Which you received.
Two, three.
233, that's it. And it's bundle reference 1-214.
06.
No, 1-214. 1-214.
No, PDF number is correct, not correct.
So the PDF number is 233, I believe.
2333, no mail.
233, just 2 3s. Yeah, that's what it is. I've got it in front of me. 233. 233.
Okay, 1 second.
No problem. Please take your time. Gives me a moment to have a mouthful of coffee in the time.
Yes.
Excellent, thank you. And can you see the email?
Yeah.
Yeah. You see the email the 8th of March, 2019.
10th March, okay.
8th of March. The email of the 8th of March, where it says, "Dear Sadir, please find attached DNA reports." Can you see that?
Yeah, I see.
Yep, excellent. So do you agree that on the 8th of March 2019, you were sent from ECOLOG DNA reports via email about cod, haddock and plaice?
Yes.
Yeah, and you responded on the same page we can see on the 10th of March 2019, didn't you? And you responded saying, "Noted your mail," and this is in response to having read the reports. "Please note that we got this products from our supplier, same condition, and we send to you same way. We will contact our supplier and will be intimated to you accordingly. In future, we can do DNA test. It will cost extra. Please advise."
Yeah, I already tell this. I am the salesperson. I want to keep the customer the good way. That's why I sent the mail. Yeah, this is in the future we are doing. The ECOLOG never asked for the test, DNA test.
Okay.
That is why I told the mail in the future business we have to do this DNA test.
Right. Well, there are two things that come out of that actually, and it's very helpful that you raise one of them for me, Mr. D. You already had preempted what I was going to say. So in your email, you're highlighting that actually you hadn't done a DNA test and you hadn't sampled it, and that therefore you were asking for future scenarios that ECOLOG would pay for the DNA test, not that you had done the DNA test.
No, future business. I'm meant by this is a future business. The lot of product. No, that is
So
the testing charge is very high. No.
So what you're saying in this email is, we've had your DNA reports. We've seen that there are issues. If you want us to do a DNA test in the future, we will, but it will cost you extra.
No, this is I want to continue this business. That is why I told this is to do this DNA test in future business.
But you're not saying, "We don't agree with your DNA reports because we have another DNA report that shows that the fish we gave you was right." That's not what you're saying, is it? You're saying in future we will do a test.
This that DNA report, because at the same time we take the DNA.
You don't say that, do you? You say you'll do it in future.
We know very well we are giving the complaint product, no any other issues. We are giving the correct product.
For future reference. And you also say that the products from our supplier, same condition, and we send to you same way. So this is going to go back to what Judge Martin was referring to you earlier on, which is how this is packaged and what you do with it. Because what you're saying here is all you are is just a processing company that just moves along what you've already received.
Yes, we are the processing company. We have to do this packing and for loading facility.
You don't say that in that email, do you? You say that you supply in the same condition and send in the same way.
Yeah, we import the same product the same way, we pack and send.
Can I ask now for you to turn to PDF 374, bundle reference 05-60.
Reference 05.
05-60, it's PDF 374. The email actually starts on 05-59, where it says the date, but I'm just going to refer you to the contents. But for transcript purposes, the email is dated the 16th of July 2019, and it's from ECOLOG to Eastfish.
Okay, see this mail, okay.
Okay, got it, excellent. Now, this email is addressed to you, isn't it? You're included in the to list.
No, I am not agree this one.
Are you not? Okay, well, if we go to the bottom of 05-59, we can see that it goes to George, CS, and Sadir. Is that you?
Okay.
Okay, do you agree you're included in the email chain?
I not agree this disposal.
Okay, so Sadir is not you.
Yeah, so this mail I sent, no.
Well, sorry, I'm getting confused now. I do apologise. So you're telling me that where the email at 0559 gets sent from Alexander Gelov, and it goes to Sadir at Eastfish, and we then get a response from Sadir marking executive, and the email address is SUDHIR at Eastfish, but you sign it off as SUDHEER. That's not you.
The same page?
I'm looking at 05-59. Are you telling me that the references to Sadir on this page is not you?
It's me, okay.
Is it you, yes or no?
Yes.
So you were included in this email, and you did send the email of the 22nd of July.
22nd July.
On 05-59, because of the way the pages are, I apologise, I'm having to flick between the two, but if you scroll your PDF, you should be able to look at both documents.
16th July.
So the 16th of July, okay, we'll do this again. It says to George at Eastfish, CS at Eastfish, Sadir at Eastfish. Do you agree, yes or no, that Sadir at Eastfish is you?
Yes.
Yes. Okay. So when you said before no.
Sorry. Hello. Hello.
Can't hear you, Ms. Walker. Ms. Walker, we can't hear you. You might need to rejoin us.
I really appreciate the patience, Your Honor.
These things happen.
Yes. Mr. Sudhir, can you hear us?
Yeah.
Try again, Ms. Walker. You're back with us.
How are we doing with sound?
Yes, we can hear you.
Excellent.
The picture is a little delayed, but the sound is fine.
Excellent. I think it will take a little moment to restart again. Apologies, Mr. Sadir. I didn't realise you couldn't hear me. Mr. Sadir, so we're just looking at that document, that email. Can you mentioned before that you weren't included in that email and that you aren't the Sadir at Eastfish. Are you now telling me that that is your email address, that actually you gave me a false answer? Mr. Can you hear me?
Yes.
Yes. Did you give me a false answer when you said that wasn't your email address? It's a yes or no answer. Did you give me a false answer when you said to me, that is not to me? And I took you to your email and you said that isn't from you. That was false, wasn't it?
No, that time we want to continue business with ECOLOG. That is why we send the mail. No.
That's not what I'm asking. That's not what I'm asking, Mr. Sadir. I'm asking you, did you give me two completely different answers to a simple question, which was, is this you? Did you receive this email? And you said, no. Are you now saying that you agree with me that that is your email address?
It's okay, but this is a mail. These are technical things, no? These are DNA.
No, Mr. Sadir, this isn't a technical question. I asked you, is this your email address on this page? And you said no. And then I asked you, is this your email that you sent on the 22nd of July? And you said no. So what I'm putting to you is
mail I sent, no, this is mentioned, no, my mail ID.
So you're not Sadir at Eastfish?
Yeah, so there is fish.
Is that your email address? What is your email address, Mr. Sadir? Mr. Dinesh, I think this is a straightforward question that Mr. Sadir can answer. I don't believe you need to interject.
I just want to help you out. See,
No,
I'm not
no,
going to.
Mr. Dinesh, I don't think you should be prompting. I think,
Yes.
Mr. Sadir, you heard the question.
I was on a different issue. I was on a concession. I can, may I say so? I'm not going to argue that this is not his email or that is not received by him. So I think most of the questions based on the.
But Mr. Dinesh, this is a matter of credibility. So I don't think you should interfere, Ms. Walker.
Thank you ever so much, Judge. Mrs. Sadir, I'm going to ask you again, what is your email address? You must know your email address, Mrs. Sadir, because you are an individual that emails people as you said, you're in the marketing and sales team. What is your email address?
Mr. Sadir, it's a simple question. Can't you answer it?
So this is yeah, yes, my mail. Okay. So, yes.
What is your email address, Mrs. Sadir? Can you tell the court and myself what your email address is?
Sadir at eastfish-ua.a is my mail ID.
Okay, thank you. And on the bottom of 05-59, it says Sadir at Eastfish, doesn't it?
Yes.
Yes, and in the email of the 22nd of July on 05-59, it's from you, isn't it?
Yes.
Yes, and actually, Mrs. Sadir, what you did a moment ago was that you didn't tell the truth under oath because you told me that that was not your email.
No, this is my mail. I didn't tell. No, this is my mail. Okay.
Yes, but what you did a moment ago was that you gave two different answers. One was false and one was true. And it's very important that that's put to you because of the fact that actually what you did was you gave false evidence, I would suggest, under oath. Now we've clarified that this is your email. I'd like now to turn to the 05-60 page, which is the email you received on the 16th of July. And this has come from Mr. Gelov. Now, do you agree that this email sets out, as of the 16th of July 2019, what ECOLOG says are the issues that have arisen by Eastfish? Do you agree? Because what I can read it to you if it assists. It says the non-compliant seafood products under the POs were delivered to ECOLOG's client for consumption, namely the UNMISM in Mali, MINUSMA as we know it to be. The primary claims quantity has been sent on for glaze variants, and the total claimed amount has been changed based on the amended NCRs. And it goes on to discuss that. ECOLOG has formally notified Eastfish repeatedly in emails dated the 14th of February, 21st of March, 15th of April, 13th of May and 6th of June. Eastfish admitted its fault in its email dated 26th of March 2019 and stopped responding to ECOLOG's non-conformities department altogether. Do you agree that what the intention of this email is to put what legal speak we would say is put on notice, if I can turn it into layperson speak, to let you know in advance, as of the 16th of July, that ECOLOG believed that Eastfish had breached the contract? Do you believe that that is you being put on notice, you being told, Eastfish, we've got a problem, you've breached our contract? Do you agree?
No, I am not believe, because this is a local purchase order. We are packed in our facility, then their QA come and check. This is a locally local purchase order. They come and collect from our, they arrange the truck, they arrange the container, their QA come and check the product.
I don't fully follow that answer. Do you agree that this is ECOLOG telling Eastfish, we've got problems here, and we're going to tell you what the problems are? Do you agree with that as a summary of that email?
They are not tell the correct the reason.
I'm not asking about the reason. I'm asking whether you agree that that's what the email says. It says we've got a problem and we want to talk to you about this. We think that you've done these things wrong.
The sales side, I want to continue this business. That is why the mail I sent to keep the customer and continue the business.
Well, that still doesn't answer my question.
Sorry, Mr. Sadir, you're not being asked about the email you sent. You're being asked about the email that came in from ECOLOG. And it's a simple question. You're being asked if you agree that that email was indicating that there was a claim likely to be made because of your breach of the contract. You agree with that?
No, sir.
You don't. Why not?
No, because we are give the exact product, no correct product.
I'm sorry, could you repeat that answer? I didn't understand that.
So we give the product is actual product. There is no any other issues, because we give the product in our, we are not export, we give the product in locally. They come and check and satisfied, then they take this product.
But that's just not, you're just not answering the question, Mr. Sadir, but we've asked you a number of times.
I'll move on. Yeah, thank you, Judge. Moving on then to your email, Mr. Sadir, which is the email of the 22nd of July. You state, we're in receipt of your mail and very disappointed to know the contents. Please note the products we supplied to you we bought from China and we trusted them. If you deduct like this, we will have a great loss and we will not be able to survive. Hence request you to kindly pay at least 80% of what you owe, of which you owe to us. So you actually a discount of 20% on the basis that Eastfish should breach their contract, didn't you?
That is only to the business side, I am thinking. I want to continue this business.
And
The ECOLOG have our money, the big money. That is why I want to keep the business and do the business again. That's why I send the mail.
But in this email, Mr. Sudhir, you're more concerned about whether Eastfish is able to survive rather than whether ECOLOG has actually got what it purchased.
Sorry?
I'll put the question to you again. You're more concerned in this email about whether Eastfish will be able to survive than whether ECOLOG received what it purchased.
Actually, this is around 5 years we are doing this business. After the end of this their contract with the UN, I think the new bid is coming. Then they are creating this issue. That is why I sent the mail, and I want the money, this payment.
Even if what you've provided is wrong, you just want the money.
No, I cannot understand.
You want the money even if what you've provided is wrong.
Not wrong. This is as a business side, a sales side, I think.
If we can scroll up the page, if possible, to the, again, it's overlapping 2 pages. It's 05-58, 05-59, 372 to 373. We have here a response from ECOLOG on the 23rd of July. And I'd like to just take you to the final paragraph, which falls on 05-59. And I'll read it out to you. And it says, well, apologies, it starts on 05-58. We hereby inform you that we have to dispose all the non-conform products by Thursday, brackets, July the 25th, 2019. If Eastfish wishes to collect the rejected products, you will have to confirm with the exact time and date of collection, no later than COB July 24, 2019. And failure to collect the rejected products will result in ECOLOG proceeding with the disposal. Please note that due to the UN's request to dispose the rejected products and removal from the UN warehouse, we must keep the rejected goods outside the warehouse. So daily cost of $300 will apply from July the 26th. Do you agree that you were told, as you're in this email, that you were told on this day that it was necessary to dispose of the non-conform products? Do you agree with that?
So we are ready to re-export this product. No,
That's not what I'm asking, Mr. Sudhir.
I am not. We are not agree for the disposal.
Does it say
we are
Mr.
ready to re-export to UAE because we are send mails, several mails, and talking over phone. But they are not to re-export.
Completely irrelevant to the question. It's a simple question, and I want you to listen to the question, okay? I don't want to get a rehearsed speech, a monologue of what this is going to be. I want you to give me an answer to the question, okay? The question is, do you agree that it states in this email, we hereby inform you that we have to dispose all the non-conform products? Do you agree that's what it says?
I am not agree for disposal.
No, I'm not saying whether you agree with disposal. I'm saying, do you agree you were told?
I am not agree with the disposal. We are ready.
Mr. Sudhir, you're just not answering any of the questions that council is asking you, and that will go badly for the credibility of your evidence. You must listen to the question and answer the question that is asked. It's not an occasion for you to make a speech. Your obligation is to answer the question. Now, the question you're being asked is a simple one, and it is simply, what is in the email? Do you agree that the email tells you that the products will be disposed of?
I cannot understand, sir.
Okay, right, if you can't answer, do you agree that it says, if Eastfish wishes to collect the rejected products, you will have to confirm with the exact time and date? Do you agree that's what the email says?
Yes, we send mail, no? They are asking for, they are not supporting for re-export.
Mrs. Steer, I'm not asking that. I'm asking, do you agree with those words, that that is what ECOLOG said to you on July the 23rd? Does it say that in the email, yes or no?
Will you repeat?
Of course. Do you agree that the email states, if Eastfish wishes to collect the rejected products, you will have to confirm with the exact time and date? Do you agree that it says that?
For the rejected product?
Does this email, the document that we're all looking at, does it say these words, yes or no? It really isn't a hard question, Mr. Sadiq. You're simply reading the page.
Which page number?
05-58 to 05-59, PDF 372. Does it say those words? Now, I know that, Mr. Sadir, you're proficient in reading English because you read your witness statement before, so I'm asking for you to read that line, please. And do you agree with what I've said as being the sentence? I don't want a rehearsed answer, I want the answer. If Eastfish wishes to collect the rejected products, she will have to confirm with the exact time and date. Does it say that sentence?
Yes, we are getting the permit from our municipality. We sent the certificate for the re-export.
Again, that's not an answer to the question, but I'm going to move on because otherwise we're going to be reading this paragraph for another 45 minutes. Can I ask finally for you to confirm the final sentence of this email? The beginning of it says, please note, due to the UN's request to dispose the rejected products, do you agree that that was said by Alex on the 23rd of July to you?
No, I am not agree because we are ready for the return of that goods. No. This is
Could you please read
our
the email? Please read the email 0559. Read with me if that's possible. Just under the words best regards Alex, it says, please note that due to UN's request to dispose the rejected products. Are you saying that I am misreading that line? I want you to answer that question, not answer another question.
It's possible, no?
Does it say, please note that due to the UN's request to dispose the rejected products? Are they the words on that line?
We are not giving the direct to UN, no. We give product to ECOLOG.
Mr. Sadir, I'm not asking for you to tell me any information. I'm asking a yes or no question. Does the sentence say that? Please note that due to the UN's request to dispose the rejected products. Does it say that in that email?
No, you are not rejected the product, no.
So I'm not reading this email correctly. That's what you're saying. An ECOLOG never said that in an email dated the 23rd of July. Mr. Dear, this is a really straightforward question. I assure you, I'm not trying to trick you. I'm simply asking you what that line says and whether you can agree that that's what it said on the 23rd of July. That's all. If you're unable to answer the question, then let me know and we'll move on. That's also a simple question, Mr. Sadir. Are you able to answer the question, yes or no? Or are you being actually told, which I'm a bit concerned about because there's a lot of reading going on, are you being told what potential answers are, Mrs. Sadir, while I'm asking you questions? Is that why we're getting long pauses here? Because you're not able to answer yes or no answers.
Can you repeat the question again?
Mrs. Sadir,
Yes.
are you at the moment being given assistance in how to answer my questions?
I cannot understand, no, what you say.
Sorry.
Is anybody communicating with you, Mr. Sadir? Are you getting any emails or is anybody sending you any messages?
Yes, sir. I got mail from ECOLOG.
From where?
From this, this mail, no.
But while you are giving evidence now, are you getting any messages from anybody?
No, no.
Mrs. Sadir, I'll ask one more time. Are you able or not, because if you're not, we'll move on, to answer the question with a yes or no answer as to whether 05-59 states, please note that due to UN's request to dispose the rejected products. Can you answer that question? That's what it says, and I'm reading off a page which is in front of you.
No, I know this only they send the mail. They are not providing any certificate or UN mail. Only so send the mail from ECOLOG.
So you agree that I've read that line correctly?
Yeah,
that's what it says.
ECOLOG saying this is rejected from UN.
Thank you. That took
not providing any documents from UN.
Okay, well, a lot longer than I was expecting. It was, I do assure you, Mr. Steer, it was a simple question, and I'm pleased we're able to now move on. Could I ask you please to turn to its bundle reference 6-579, and for some reason I have not managed to put the PDF to myself, so if you give me one moment, I will be able to get the PDF reference for 6-579 to assist you.
579.
So it's 6-579, and this is an exhibit to your witness statement. And it's a PDF 2429. Let me know when you're all there.
PDF number 579.
Yes, it is.
579 05266.
06-579 PDF 2429. It's exactly the same document we've just been looking at.
PDF is not correct. 5.
PDF is 2429 and the trial bundle reference is 06579.
No, PDF number
2429.
2429.
Yeah. I'm taking you just so you can see that this actually is a page from your witness statement. So I'd just like to understand why it took so long for us to get through this document. Because you've relied upon this for your evidence.
Zero 6579.
That's it, yes, and it's an exhibit to your witness statement. So I just want to draw, I don't know whether it's a more familiar document if you see it like this. Is it more familiar to you looking at it this way? It's exhibit 8 to your witness statement.
Received this mail.
We've just looked at it. It's exactly the same document as before. It's just that this time someone's highlighted it in relation to your exhibit 8. Now, Mr. Sadiq, can I...
At the same time, we are ready to re-export, no? Here.
Do you now agree with the contents of this email? Do you agree that this email...
We sent several mails. We sent. They are asking for the permit from municipality of Ajman, UAE.
Oh, ECOLOG.
We will talk to our phone. Also, this is we are ready to return back this rejected product.
You exhibited it to your witness statement.
1 second, Mr. Sorry. Yes, Mr. Sudhir, please understand the question and answer the question. You don't repeat whatever in your mind every time to every question, please. You understand the question and this time is wasted and you are repeating one paragraph like a parrot repeatedly, same thing and again. You please appreciate the question and answer the question. This is a cross-examination. You are supposed to answer the questions, not sitting there and wasting the time.
Sorry.
Ms. Walker.
Thank you. Can I ask you to confirm that this is the same document that we've just been reading a moment ago, which is the email from ECOLOG, which you've exhibited to your witness statement? Do you agree? It says the same wording, doesn't it? Please note that due to the UN's request to dispose of rejected products. It's the same document we've been looking at, isn't it? Just a different page number.
Yes.
Yes, thank you. Now can I ask, please, if we can turn to its bundle reference 5-954, PDF 1268. And it's an email dated the 30th of July. And it has gone to you. You're in the seat, you're in the 2 box.
Oh, 05-594 is not an email.
Apologies, 05-954, Judge. Which of the PDF is 1268. It's an email dated the 30th of July. So 7 days after the previous email.
Yeah, 05955.
So 05-954.
Yes. 05-954. Okay.
That's it, absolutely. 1268 of the PDF.
1268.
Apologies, Mr. Did I interrupted then? What did you say?
1268, right?
Yes, spot on, 1268, that's where I am. And we can see this is an email 7 days after the previous email. Again, it's from ECOLOG, it's from Alexander Geloff. And it's dated the July the 30th, and we can see you're included in the CC box. And it says, ECOLOG is willing to assist Eastfish recover the rejected goods, provided that Eastfish acts promptly and in good faith. The UN has a specific procedures to withdraw rejected goods from any of its mission that are labelled for UN consumption. In order to obtain the export release document from the UN, Eastfish must provide an import confirmation from the country of destination. ECOLOG requires Eastfish to provide this document within 2 business days. Failure of Eastfish to provide this import confirmation with a deadline will result in ECOLOG immediately proceeding with disposal. On receipt of the import confirmation from Eastfish within the deadline, ECOLOG will extend the deadline for the recovery of the rejected goods for a further week. So we can see here that ECOLOG has responded and extended the deadline, haven't they?
The same time in UAE, the Eid holiday, we are not getting the certificate. That is why, but we are communicated always in the phone and mail.
But we saw, didn't we, in the previous email that the date for disposal was going to be the 24th of July. It's been extended by ECOLOG. So ECOLOG has extended the time, haven't they?
We are produced that certificate.
But ECOLOG extends the time, doesn't it? And it explains to you, you, and I say you because you're in this email, that you must provide an import confirmation from the country of destination. It asks you to do that because it's trying to get your help in helping you recover these goods. And then it's saying, if you don't do it by this deadline, there's nothing we can do. We're going to have to dispose of these products.
Before the deadline, we produce the certificate.
Well, we're going to get to the point at which you provided the certificate because it wasn't before the deadline, was it? So we're now going to go to 5-952 bundle reference 1266. So it's 2 pages away from where we are now.
PDF number?
1266. It starts. This is dated the 30th of July, so the same day as we've seen the email just now. And this is from George Varghese. You with me at the bottom of 05-952 PDF page 1266. And this is in response to ECOLOG's email from Eastfish. And it says, first of all, we would like to express our gratitude for support which you have extended in your mail for re-exporting products and appreciate the mail's contents. So do you agree that that sentence is actually thanking ECOLOG for the fact that they are helping with the re-exporting of the non-compliant goods? Do you agree with that?
Can you repeat?
Of course. I'm just reading the email. Do you agree that Eastfish is expressing their gratitude for the support which ECOLOG have extended in ECOLOG's email for re-exporting the rejected products and appreciate the contents of ECOLOG's email? Do you agree with that? That's an email that came from George Varghese.
Yes.
Yes, thank you. And do you agree that in the next paragraph, where it talks about the import confirmation certificate, it doesn't discuss it being a holiday. It says that there's a technical issue in issuing the certificate, as Eastfish have to provide the actual quantity and the details of rejected products in the application for import. Do you agree it says that?
Yes.
Yeah. And then it goes on to say, we, so East Fish, have prepared a statement to quantify the actual quantity and details of rejected products based on ECOLOG's report, which ECOLOG have provided by mail. Do you agree with that?
Can you repeat?
Of course. ECOLOG, so East Fish have prepared a statement to quantify the actual quantity and details of rejected products based on ECOLOG's report, which ECOLOG provided by mail.
ECOLOG didn't provide any detail.
Well, that's not what Mr. Varghese thinks, because Varghese thinks, as of the 31st of July, that ECOLOG had provided a report. In fact, he confirms it.
No,
He says,
they are
on
not
your
providing.
report, you've provided by mail.
And I've sent to the mail the product detail, the last, but they are not to give the exact quantity.
So you're saying that when Mr. Varghese of East Fish said that ECOLOG had provided the report, that was false. He was lying.
Cannot understand what it's in.
Are you saying that when Mr. Varghese of East Fish said that the report had been provided by ECOLOG, he was lying? Was he telling the truth when he said that ECOLOG had provided a report?
No, we are asking for the re-export, but they are not providing the detail.
So Mr. Varghese is lying then?
Yes.
Yeah, okay, Mr. Varghese is lying. And what we see is a gap. And just to clarify, Mr. Varghese is of East Fish. What we see is a gap of 8 days between the last email that ECOLOG sent on the 23rd of July and the 31st of July from East Fish. Now, that's a gap of 8 days. And in that time, do you agree that East Fish didn't move forwards with the disposal, the collection process?
Yes.
Yes.
We are ready to collect. No?
But you weren't, were you, though? Because as we can see on the 31st of July, you're still not ready. So if I can ask you now to turn to PDF 1261, so if we go back 5 pages, and it's bundle reference 05-947.
PDF
1261. And it's 05-947, which is the bundle reference. 1261 is the PDF. Judge, if I may, while we're all searching for page numbers, I only have a few more questions left, which I would hope wouldn't take too long. But I'm just conscious of time. I'm not sure whether you sit normally until 4 or 4:30. I should be done by 4:30 UAE time.
Well, we've still got re-examination from Mr. Dinesh, though. So if you could, it's getting to be a long day for the witness. We've only had a short break, so let's see how we go. If we don't finish, Mr. Sudhir can come back in the morning, I'm sure.
Thank you very much. I appreciate the clarification. Mr. Sudhir, can you confirm that you're on the page?
The only thing I would suggest, Ms. Walker, is that there is a law of diminishing returns in relation to asking this witness about documents that speak for themselves. frankly.
Okay, understood.
Yeah, that's what, Your Honor, that is what I was trying to intervene in between, because I'm not going to argue saying that these documents, wherever Sudhir is mentioned, I'm not going to say that it is not of Sudhir's document. So, Ms. Emma, your job would be easier. I'm not going to confront you, or I'm going to argue contrary to what the documentary evidence are. So there is no point in putting an email and saying that is it yours, is it yours, and this gentleman is going to take, I mean, a lot of time for even answering his own email ID. So if that being the case, I think I'm not going to argue against the documents.
Mr. Dinesh, my only issue is actually your own submissions directly contradict the contents of these emails, and the only way I can refer to them in my closing submissions is that they are put to a witness in evidence, and it's due to your submissions and contradicting the contents that I am needing to go through this rather difficult process.
Well, I don't think, Ms. Walker, I don't think that normal forensic rule really has any application with this witness, because clearly he has great trouble with English. He has great trouble answering questions. You've done your best. I think you've laid the groundwork for a submission based on the documents, and Mr. Dinesh is not going to be heard to argue otherwise.
Thank you ever so much. I do appreciate that clarification, and I would just like to put a marker that there may then be a couple of documents that I refer to in closing submissions that, of course, weren't put to a witness but are going to be relevant. If I may then just refer to two final questions, Mr. Sadir, in order to try and make this process a little bit quicker, and maybe we'll be able to get your re-examination done today. Can I please ask, because you made reference to it in your witness statement, and I'd like to directly refer you to the document that you refer to. Can I ask you please to turn to page 1542 of the PDF and bundle reference 05-1228. 1542 of the PDF, and it is bundle reference 05-1228.
Reference 05-1228.
05-1228.
Okay.
And it's PDF 1542.
1542, okay.
Yeah, that's it. Now, do you agree? This is a document that ECOLOG sends requesting the rations unit representative to be present at the disposal. Do you agree that's what the email addresses? It says, hence may I request rations unit representative to be present during the disposal. We have scheduled the disposal of various frozen fish line items from East Fish Processing. Do you agree that's what this email says?
This is a mail dated on October 3rd.
Yes, it is indeed, yes.
Well, the email doesn't appear to have gone to Mr. Sadir.
It doesn't, no, but in Mr. Sadir's witness statement, he suggests that the disposal was a hoax of some form.
Oh, I see.
So, Mr. Sadir, do you agree that this is an email to the UN asking them to be present at the disposal?
So, yeah, this mail is, I see this mail now.
Now, given that this is sent to the UN, Mr. Sadir, it can't be a hoax that East Fish's products were disposed of when ECOLOG suggested that the UN were present for the disposal, can it? Or do you believe that the UN is in on it too?
But this is a ECOLOG disposal certificate, right?
So we do have that, yes, at 1549. We've got the signed disposal certificate of the East Fish products, and that's bundle reference 05-1235. And we can see it's stamped by ECOLOG, and we can also see it's signed and stamped by the Chief Rations Unit at 05-1235.
That is
so do you?
the quantity and the product is different.
So you think that this certificate doesn't in any way reflect the products that Eastfish provided? And that the UN is all part of a big conspiracy to not dispose of these fish?
The product and quantity is different, no?
Okay, well, we can actually look at the distinction between the quantities. So we can see here, there's an example of 500 kilograms of cod. And I'll get you the point because it's an easy one to remember. So if you look at UN code 1166, fish cod fillet frozen 500, batch 8J10, and it's 500 kilograms. Can you see that?
Yeah, this is a disposal certificate quantity, and this rejected quantity is different, no? Different weight.
Oh, okay, well, let's go to a document that will show that there was 500 kilograms of cod fillet as a product. And I'll ask you please to go to page 1432. It's bundle reference 05-1118. Now this is the food
PDF
exports.
113.
So it's PDF 1432. And it's
PDF.
It's bundle reference 05-1118. 1432 is the PDF. Now this is what Eastfish provided as the Municipality and Planning Department food export certificate. And Mrs. Sadir, you've referred to this a number of times. Now, if we look at this document, and let's make life simpler, and we'll go by the weight, we can very specifically see there that we have different weights. And the very first one is the exact same product we've just seen on the disposal certificate. Frozen cod, fish fillet, weight 500 kilograms. So they're exactly the same products as a cross-reference. That was what was disposed of, what you provided. And this hasn't been a hoax. And all of the goods have been disposed of because they were non-compliant, perishable, rejected items. And actually, what this has all been is a case about incorrect goods having been provided and the UN not paying ECOLOG.
Walker, this is cross-examination, not closing submissions.
Of course, but I'm also trying to make this a little bit quicker. Mr. Sadir, do you agree that there's a reference there to 500 kilograms of codfish fillet?
No, I already told you this. This is a different, no, the weight.
Mr. Sadir, it's not.
Here,
It's
disposal
exactly the same
quantity
weight.
Contradict.
Mr. Sadir, the disposal wasn't a hoax, was it? It happened.
Sorry?
The disposal happened, didn't it?
I cannot hear you.
The disposal happened, didn't it?
Disposal, they sent the photographs and this certificate, but this is not match the product and this disposal product.
And ECOLOG, Eastfish, apologies, are simply trying to grab straws to try and find a way to not be found in breach of their supply contract.
No, we are ready to return back now our product.
Judge, I've finished my cross-examination. I'm not going to put any more documents in this today.
Thank you, Ms. Walker. Mr. Dinesh, do you re-examine? Can't hear you, Mr. Dinesh. You're on mute, I think.
Your
I
voice.
can't hear you. Mr. Dinesh, I can't hear you. You are on mute.
I'm sorry. I will ask only one simple question.
Yes,
I'm
right.
conscious of the time. Mr. Sudhir, does ECOLOG know the origin of the product, origin of the product?
How can he answer that? How does he know what ECOLOG knows?
We are sending the original product to ECOLOG.
My question is different. Does ECOLOG know by any means? I don't want to ask any leading question. That's why I'm limiting my question. Does ECOLOG know by any means that the product which they have received is from such and such origin?
No. Sorry.
So far as the label is concerned, is it printed on the label about the origin of the product?
Origin not mentioned, the only packing and export.
My question is it mentioned that who is sending the product to you? Is that mentioned?
Yes,
okay.
That is mentioned. Yeah, the origin of the product. The producer name is mentioned in the label as per ECOLOG instruction. And they send all documents, the producer certification, everything.
And is the very same producer's name is mentioned when you are sending the product to ECOLOG?
Yes.
That's all, my lord. Even my own question is not able to understand. My lord, so that,
Yeah,
look
right.
at the difficulty.
All right. Well, thank you, Mr. Sadir, for your assistance. There's no need for you to be involved in this case any further. You're free to go about your business. That'll do for today, I think, and we'll resume tomorrow at 10 a.m. in Dubai time.
Okay.
Thank
you.
Thank you, everybody. Court's now adjourned. Good evening.
Sorry.